posted with Revolution News and Information. It is 10/17/2016. This is the Dave and Edward Johnston Show. They call it the Disclaimers. Without further ado, I would like to pass the floor over to Edward.
Okay, thank you for joining us, people. We appreciate to have you with us. We appreciate the education that we share with all of us. This is the whole point that it is based on proper education and research. And this is where we need to work with each other, so this way we know what the truth is, what's going on. We know the facts of what's going on. And this is the point that we need to do this. We have to educate our children. And if your children are not being educated, the school system doesn't do it, so it's your responsibility. So this is the point where we are educating each other. We do the research. We are not attorneys. We are not lawyers. We don't get involved in that, structure. And if you want legal advice, go play the games with the devil. We don't deal with that type of structure. We deal with the Constitution, and that is the law of the land. And don't forget it. That is the law. And that's the one thing people don't realize. They keep thinking we're supposed to be, or we're part of a democracy. We are not a democracy in any fashion of the word at all. We are a Republican form of government. And that's the one thing that we've got to maintain and get back to. Because technically we have a Constitution. They didn't start voting until after the Civil War. This is the problem that we have. We're not supposed to vote. We have a Constitution that says no injured party, no corpus delicti, no victim. And that's what we need to go by. And we need to get this back structured in our homes, and we need to get this structured through our system properly educated. And that's the whole point. We need to educate ourselves. And so if we don't educate ourselves, nobody else is going to do it for us. And that's where people need to really start waking up to life when it comes down to it. Waking up to what's really going on around you. Waking up so you get to know the structure of what's legal and lawful. We do have a legal and lawful system. And people keep going off, and I want to hit it briefly on taxes. Everybody's going, we need to get rid of the IRS. Folks, the IRS is supposed to be tax collecting for elected and public service, registered church member, and immigration. All right, lawful Americans do not pay taxes. Read the Constitution. Read your law. And that's the point. You need to know what our agencies are supposed to do. You need to know what they're capable of doing. We would like to see the so-called FBI do their job instead of quit covering up for these criminals. And that's exactly what they do, is they cover up for criminals. And then this is disturbing. We're supposed to be having, rights and not privileges. And that's the only way we can be able to do that is insert your rights. If you don't insert your rights, nobody else will do that for you. Okay, so it's just looking at the structure here. We are glad to have everybody joining us. And we'll get to questions and answers here in a little bit. We'll be introducing Michelle again. So we could go back dealing with some of the stuff on foreclosures. And so it's very important that you pay attention to these things, because Michelle, has been working on her structure. She's brought this to light, and this is the point. We have a light on the structure. Now it's time that we need to start working with that light and moving it around so we can protect our homes, our land. And this is the point. It's our land. And I'm one of those advocators, because I can't wait to send Muslims home and shut this country down from all the invasion we're getting. I mean, I read an article where Obama was going after our military because they weren't showing respect to Muslims. Sorry, you have no rights in this country. And the first war that started with the Muslims was 1801 to 1817. And read it. It's the worst war in history. These people do not care. You know, that's the bottom line. You know, they don't care. And it's frustrating because, you know, we get people that get too compassionate and don't even know what their country and standing is about. And this is why we've got to learn this stuff. We got to pay attention, protect the homes, protect the kids. Because that's what we need to do, is we need to start protecting our country. Because nobody else is going to do it, and the rest of the world don't care about us. So, and that's the point. When they really don't care about us, and then everybody wants to go give handouts, to me that's very disturbing, very disturbing. So, but anyhow, I guess Dave hasn't shown up yet, so I'm sort of shocked on that one because I got off the phone with him a little earlier, and he said he was going to be on the show. So anyhow, well, like I said, we're going to start getting into this stuff with Michelle. She's going to open up on dealing with, and so that's the point we need to deal with. Anyhow, hang on just a second. I don't know if this is Dave or not.
Ladies and gentlemen, we apologize about the dead air. But it is the nature of the beast.
Anyhow, I'm back.
I'm going to pass it back to you, Ed.
Okay, thank you. Anyhow, this is the point that we need to work together and start implementing our rights and knowing what our rights are instead of interpreting stuff. And no, that wasn't Dave. But anyhow, I do want to get into turning the floor over to Michelle, and this way she could get into introduction of what she's done, what she has done the research on, what she's put together, so this way you could all see. Excuse me. This way you can all see.
Can I say something good? Ed, can I say something to you? That one question you had about why we give handouts to the other countries, that was a good one, but the reason is because they take part of the handouts they're giving out. What do you think?
Well, that's the point. We got to stop giving handouts, period.
I'm telling you,
we don't have the
guys,
food resources and that type of stuff to provide for everybody. We can't even take care of our own people.
Well, see, that's not the point. The point is who's giving it out is taking part of it.
Yeah, it's called elected and public servants.
Yeah, it's the 101. Common sense 101. The only reason I'm giving you
there's Dave. Hang on.
Thank you, hon. Love you.
Sorry about the dead air again. Y'all, gotta love those technical difficulties. So, yeah, y'all.
Sorry about that one.
And you got the floor, Ed. Go ahead.
If you got 765, that's Dave. Did you hear me? Hello?
Did we lose him?
Dave. This is Dave. Okay, there's Dave. Who's who? Okay. So anyhow, I'm going to turn the floor over for Dave, and so that way he get in, and then we'll get Michelle on this and start going through the foreclosure structures. So anyhow, go ahead, Dave. I'm passing the floor on to you, and also too tonight when you we want to start getting things organized here. So when you start speaking, and wait till somebody else is finished speaking before you speak, and say my eye until we can get to be on. So this way we can start not having mass confusion and people not talking over people. Anyhow, the floor is yours, Dave.
Good evening, ladies and gentlemen, and welcome to our show. It's always great to have you join us. Currently, I am in New York, state of New York. I've been visiting some friends in Vermont this weekend on our way home. And the foliage here is absolutely breathtaking. If you like the fall colors, this is the week to do it. In regard to last week's show, it was a huge success. And we're glad that Michelle's back with us again tonight. And we are excited about our new webpage that's being created as we speak. And a lot of things are going to be public knowledge posted to that website. So you need to, New Oregon Trackers is the name of it. Need to let your friends know that it is up and running currently, and we will be adding to it daily until we get it where we actually want it. So feel free to visit New Oregon Trackers. And Ed, I don't want to take up any more time because I know Michelle and our other guest have a lot of ground to cover tonight, and I don't want to take from that. So with that, I'll turn it back over to you to introduce our guest.
Okay. So I'd like to introduce Michelle, and I'm not sure where she wants to start, but I think that we should start right at the place where she was at last week, and so she recalls that, or just go free. So, Michelle, the floor is yours.
Hi, everyone. I'm glad to be back, and I thank you for having me on and also for your hard work. I am going to be addressing several different things. It's education. I'm going to talk about a few things going back in history as going back to the 1400s. So you'll understand a little bit of the history as to what Ed and those that are aware of what Ed's been talking about, to kind of get an understanding what he is saying. I'm also going to be reviewing some documents regarding some laws and statutes, so you can jot them down and you can Google them in your search bar so you can read them for yourself at your convenience. I have a lot of material to go over, so bear with me because I'm going to be bouncing around over several documents. I'm going to start out by, first I'm going to start out with a little bit of some understanding regarding the courts. So just bear with me for a second so I can kind of get my thoughts on that, okay? Okay, first I want to start out by addressing what is a contract. And this is a definition. The definition of a contract. A standard form contract drafted by one party, usually a business with stranger bargaining power, and signed by the weaker party, usually a consumer in need of goods or services, who must adhere to the contract and therefore does not have the power to negotiate or modify the terms of that contract or the contract. It's important, you want to write this down, it's called an adhesion contract, and that is A, D as in David, H as in him, E as in Edward, S as in Sam, I as in, O as in on, and N as in Nancy. So it's ADHESION contracts. Adhesion contracts are commonly used for matters involving insurances, leases, deeds, mortgages, automobile purchases, and other forms of consumer credit. Also known as adhesion contract, adhesory, that's ADHESORY contract, and that has to do with take in or leave it contract, Leonin contract, and that's L. I think that's how you pronounce it. So if I'm not pronouncing it correctly, forgive me, but it's LEONINE contract. Courts carefully securitize adhesion contracts and sometimes void certain provisions because of the possibility of unequal bargaining power, unfairness, and occasionability as factoring into such decisions include the nature of the onset of the possibility of an unfair surprise, lack of notice, unusual bargaining power, and sensitive unfairness. Courts often use this doctrine of reasonable expectations as a justification for invalidating parts or all of the adhesion contract. The weaker party will not be held to adhere to contract terms that are beyond what the weaker party would have reasonable expected from the contract, even if what he or she expected was outside the strict letter of the agreement. Now that is the definition of a contract. Bear with me. Now when you're in court, and for those that are addressing the court as to your document, I'm going to read how I used my wording, and of course, at your leisure, you can use your own wording. But I'm just going to kind of give you a little phrase as how I worded it, and of course, as we learn, we always correct our mistakes. So I started my answer to the complaint, because after all, I was the defendant, they are the plaintiff. So I started out by saying this: I, Michelle M. Christensen, one of the people of Florida, hereinafter counter plaintiff, accepts the oath and the bonds of all the officers of this court, and moves this honorable court to quash, for lack of authority, of personam jurisdiction. Given that this court's jurisdiction is barred because this is a Nazi Perez court and not a court of record. The Nazi Perez is an old English term pertaining to the courts violating your rights, and they're not addressing the court properly. Now that is how I started out, by saying who I was as me being a people. Because I know a lot of people ask the question, how do I represent myself as one of the people? So that's how I started myself as a living being. Now we're going to go into some other codes, and this is penal code. Now you have to, yes, sure. Sure. I don't think I have anything in the background coming from me on my end. Oh, okay. So now you have, those that are listening, penal code is something that lawyers and attorneys do not usually go for, because penal code is, in other words, it has a higher standing evidently under law. So a lot of them address statutes and codes. They don't usually use penal codes. Unless, of course, they're really up against somebody that knows what they're doing, then they might cite the penal codes regarding the law. And just so you know, statutes and codes are not law. They define the law. All right, now this has to do with mortgages, of course, and this will, when you look at your contract now as to your mortgages, you will see this law as in your contract. Now, this has to do with proof beyond a reasonable doubt. If you don't bring evidence as to what you're claiming as an exhibit regarding what you're claiming as you being the plaintiff, or as what you're addressing as an answer as a counter-cross defendant, if you don't have any evidence to back up your claim, then they are going to walk over you. But as soon as you say to the judge you have an exhibit to back up the claim, that changes the whole scenario of your statement. So it's very important that you have proof of beyond of reasonable doubt. Now that will be Penal Code, Title 1, Chapter 2, Burden of Proof. And you can Google that in your search bar to print out the documentation under what falls under beyond proof of a doubt, okay? Which is called proof beyond a reasonable doubt. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. Now, keep in mind, I'm using the word person because we're talking their language. We're not talking our language under natural law. This is their document. These are their laws, so I'm speaking in their tongue. Section 2, now, and that would be, by the way, that's Title 1, Chapter 2, Section 2.01. Proof beyond a reasonable doubt. Section 202, exemptions. And that would be A, excuse me, exemptions to the application of. Now I'm going to read that sentence, but I wanted to say that before I read it so you would understand that is kind of like your highlight. I'm highlighting some areas under that paragraph. So Section 202, exemption. That would be A, small a. An exemption to an offense in this code is so labeled by the phrase. It is an exemption to the application of. B, the prosecuting attorney must negate, and that's negate, the existence of an exemption in the accusation, charging, commission of the offense, and prove beyond a reasonable doubt that the defendant or defendants' conduct does not fall within the exemption, meaning that you have to prove beyond proof of reasonable doubt regarding your evidence. If you can prove that against them, you're going to win your case. Hang on a minute, I'm going to go to the next page. Oh, almost lost the phone, sorry. Okay, this is Section 204, and that would be 2.04. Affirmative defense. An affirmative defense is this code is so labeled by the phrase. It is an affirmation defense to prosecution. You're going to jump down to C of that Section 204. Unless evidence is submitted supporting the defense. Now you have to understand this is where the grand jury would come into play. And under C, it says the issue of the existence of an affirmative defense is not submitted to the jury. Now you're probably asking, what do I mean by that? The jury, or you as the party bringing in your defense as evidence, if you don't have evidence to back up your claim, then the jury cannot hear that claim. So you have to have evidence to bring it in, to have a grand jury look at your evidence. Does that make sense? I hope you understand what I'm trying to say. Bear with me, I'm moving along here. Okay, now that had to do with proving proof beyond a reasonable doubt as to what you would have to prove in court under those under the Penal Code, which is Section Title 1, Chapter 2, Section 2.01, Section 2.02, and Section 2.04. So you're going to Google those in your search bar, and you'll be able to pull up that form and read it. Hang on, bear with me. Judicial, bear with me, I have a hard time saying certain words sometimes. This says judicial cognizance, and that's COGNIZANCE. Counter plaintiff moves the court to take judicial notice or knowledge upon which a judge is bound to act without having it proven in evidence. Remember, we're talking about proving evidence as to you being either the defendant or the plaintiff regarding bringing evidence upon the court as making a claim. You're the claimant, or as a plaintiff, okay? The doctrine of estoppel, I think that's how you pronounce it, ESTOPPEL, stare decisis, ETNON, quote movere, and that's QUIETA MOVERE. This court must adhere to authority. The doctrine of the stare decisis is but an application of the doctrine of the estoppel, ESTOPPEL. And that would be Brown versus Rosenberg. Now, when you do the, you can Google this in your search bar to get these statutes and codes that I'm reading to you as far as going over a few things. Statutes are not law, as we all know. That falls under a Nazi. Pereira's court relies on statutes, which is not law, that seeks to control the behavior of the sovereign people. Okay? The jurisdiction must be proven, not decided. The law requires proof of jurisdiction to appear on the record of the administrative agency and all administrative proceedings. No sanction can be imposed absent proof of jurisdiction. The court must prove on the record all jurisdiction facts related to the jurisdiction inserted. I'm skipping over the case laws, but you'll be able to look those up when you do Google search. Once challenged, jurisdiction cannot be assumed. It must be proved to exist. No sanction can be
Yeah, I got it. Yep, I got it. I'm here. Anyhow, wait till Michelle gets back and we'll continue on this. The 1.2 is go down to the county building property managers and go look up on your property. Do a research on your property too, see how far it goes back, because if your title goes back on the structure of 1890, you file a Homestead Act on your place. That's what I'm getting ready to do myself.
And I will touch on that. Too. Can you hear me now better? I'm sorry.
Yeah.
Somebody was cutting in. They were calling me on my phone, and that's why I all of a sudden. So I'll start back up on the jurisdiction must be proven, not decided. The law requires proof of jurisdiction to appear on the record of the the administrative agency, and all administrative proceedings. No sanction can be opposed absent proof of jurisdiction. Court must prove on the record all jurisdiction facts related to the jurisdiction inserted. Once challenged, jurisdiction cannot be assumed. It must be proved to exist. No sanctions can be imposed absent proof of jurisdiction. The town and city courts have no jurisdiction over the people. Service of an appearance ticket does not confer personal jurisdiction upon a criminal court. Only Congress can make an act a crime, affix punishment to it, and declare court that shall have jurisdiction. So if you have criminal, they're the only ones that can bring that into the court, like I'm fixing to do now. Appearance ticket is not accessory. Appearance ticket is not accessory instrument, and its filing does not confer jurisdiction over defendant. Service of an appearance ticket on an accused does not confer personal or subject matter jurisdiction upon a criminal court, and that would be People versus Gosset, and that's Giusti. Trial court acts without jurisdiction when it acts without inherent or common law authority, and that would be Steve versus I'm not sure how to pronounce the word. I think it's Ridigus, and that's Rigues. I'll spell it again. Rudriguez, not S, I'm sorry. Criminal law magistrates have no power of their own and are unliable to enforce any ruling. This court does not have jurisdiction or common law authority. Every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. That's where we come in as under natural law, and that would be Crodin versus Neal, and that's Cruden versus Neale. Without an injured party, no court has authority over a civilian. The U.S. Constitution, under Article 1, Section 8, Clause 17, grants courts jurisdiction under common law, or admiralty law, or military tribunal venue. Common law is preserved under the Supreme Courts and other courts of record as defined in our U.S. and the state constitutions. Legislatures are authorized under the Constitution, ordained by the people to write statutes and codes enforced as law, to control bureaucrats, municipalities, government agencies, elected officials, interstate commerce, but not people. I'm going to go on. By the way, I'm citing off of my documents. This is what I had presented in court myself, just so you're wondering where I got this. Case cannot proceed one step further and must be dismissed. When challenged, jurisdiction must be documented, shown, and proven to lawfully exist before a cause may lawfully proceed in the courts. However, let this objection has been made or may be made in any case in an inferior or appellate court of the United States, it must be considered and decided before any court, meaning regarding appeals. Immunity loss to proceed without jurisdiction is treason. Any judge who does not comply with his oath to the Constitution of the United States swears against that Constitution and engages in acts in violation of the supreme law of the land. The judge is engaged in acts of treason, and that's Cooper versus Aaron, and that's A-R-O-N, and that would be, of course, Cooper versus Aaron, and that's C-O-O-P-E-R. There is a general rule that magistrate officer who acts wrongfully, although in good faith, is nevertheless liable in a civil action and cannot claim immunity of severance. Remember, we're innocent until proven guilty. The courts are not bound by any officer's interpretation of the law under which he presumes to act. When a judge knows that he lacks jurisdiction or acts in the face of clearly valid statutes expressly depriving him of jurisdiction, judicial immunity is lost. Meaning that if they don't have, if the judge is addressing the court just on hearsay, on statutes and codes, remember, he has no standing because he has to have valid laws and evidence to prove his claim to take control of that jurisdiction. Hang on. The courts are not bound by an officer sorry, I already said that. A judge must be acting within his jurisdiction as to subject matter and person to be entitled to immunity from civil action for his acts. When a judicial officer acts entirely without jurisdiction or without compliance with jurisdiction requests, he may be held civil liable for abuse of process, even though his acts involved a decision made in good faith that he had jurisdiction. So if you bring a case into court and you have proof that he violated your due process rights, he can be held liable. No judicial process, whatever, from it may assume, can have any lawful authority outside of the limits of the jurisdiction of the court or judge by whom it is issued, and an attempt to enforce it beyond these boundaries is nothing less than lawless violence. Unlawful town court practices and a warning to prosecutors. Now, this is a warning that you can make in court as putting them on notice. It is a common unlawful practice for town courts, magistrates, and prosecutors to meet privately to plot an answer to a counter plaintiff in an attempt to unlawfully maintain jurisdiction under color of law, and that would of course be also under state law, and opposed to studying its contents. Therefore, the court should proceed with prudence, forewarned of this following. It is not up to the prosecutor to prove jurisdiction, but the magistrate. The prosecutor is not to write court rulings. The magistrate is not to meet an ex parte with the prosecutor for any reason. For the magistrate to discuss this case with the prosecutor without the counter plaintiff present would be nothing short of an anything short of entangling, alliance, criminal, conspiracy against counter plaintiffs' unalienable rights, causing the counter plaintiff to file an action for conspiracy to commit malicious prosecution. Conclusion. In a conclusion, this court is a Nazi Perez court, created by statutes, sanctioned by statutes, ruled by statutes, and not constitutions. I am one of the people under the law of the land, aka common law. Statutes are not law. This court has no jurisdiction over the counter plaintiff, nor can this court prove otherwise. Therefore, this court is barred from jurisdiction in this case. For the officers of this court who constable are sent out on the highways, designation under color of law to kidnap people conspiring to maintain constructive custody, and thereby preventing counter plaintiff free exercise of his unalienable rights, carries serious consequences. Shall this court illegally proceed, such consequences shall be applied against all officers of this court and court of law. Wherefore, counter plaintiff moves this court to enter an order discharging this case for lack of personam jurisdiction, as is this court's constitutional duty. You would date it and you would sign it. Now that is my document that I just shared with you, me representing myself in court. Now we're going to go on to some history. I already explained to you about the contract, which is the adhesion contract. Keep in mind that it's very crucial for those that are facing foreclosure. You have what's called an adhesion contract. Now before I read some history here, and we go into that, I want to also tell those who have addressed the court. If you have already addressed the court and they have ruled on your on your case, you want to file a motion to vacate final judgment for foreclosure and incorporated memorandum of law. That is what it's called. It's called a motion to vacate final judgment of foreclosure and incorporated memorandum of law. And what you would say is comes now, you, as you being the defendant, and you hereby file this motion to vacate final judgment of foreclosure and in support thereof states as follows. And then you would outline the dates pertaining to when you went to court, and of course you would outline what they have brought forth upon you under fraud. And then you would indicate your conclusion, which would be you currently stand to lose your home by virtue of a lawsuit which at this time contains disputed issues of material facts. And the final judgment of foreclosure must be vacated, in this case because defendant's fundamental right of due process has been violated. As a current owner of the property who stands to lose her or his home, the defendants, which would be you would be the defendants. Hang on a minute, just a second. Okay. Yeah, you're addressing. I had to check to make sure I was indicating that right, as you being the defendant. So the defendant's lacks of familiarity with the court system led to excusable neglect. However, defendant is now requesting an opportunity to be heard prior to the writ of possession being entered against her property. Because remember, the last thing that they did upon you when you lost your home is they filed what's called a writ of possession, and that's what they used to take your home. Now, if you have gone to court before you have received your notice of writ of possession. What you want to do is you're going to go to the property appraisal's website. Now I'm going to give you some information as to what Ed was referring to. There's different things that are going to come up when you go to the and it would be your county. So mine says Lake County Property Appraiser, just so you have an idea. So yours would be of your county property appraiser, and that's where you're going to go to find these forms. These are forms now that will come up under the property appraiser's website. Exemptions, which would be a homestead exemption application, and that you would find under capital DR-501. They have different forms here, so I'm going to cite some of them. Limited income seniors exemption application, and that would be under capital DR-501SC. Now I'm citing Florida, of course, under those definitions, but when you put in your state, it will come up under the proper code if it's changed pertaining to those forms. Transfer of homestead, exemption difference, save our home portability. Application is DR-501T. Designation of ownership, shares of abandonment, homestead. That is one you'd want to look up, and that is DR-501TS. Let me see, because there's many things we can go over, but I'm not going to list them all because you can look this. I'm sure when you go to your website, you'll see what I'm saying. These will all come up. Physician's certification of total and permanent disability. I know there's people on disability, so that would be DR-416. Another one under disability would be also DR-416B. DR-501M. Let's see. Instructions for Lake County Business Tax Receipt Registrants. Tangible Personal Property Tax Return, and that would be DR-405. Request for an extension of tangible personal property, affidavit of change in tangible personal property, and that falls under DR-405. Value Adjustment Board. Let's see if there's anything you need there. Here's something pertaining to petitions. Petition to the Value Adjustment Board request for hearing. This is one you definitely would want to look up because, after all, you're claiming identity theft. And that would be under DR-486. These are petitions now. Attachment to petition for multiple units. If you have multiple units, like in an apartment or whatever, that would be DR-486MU. Petition for transfer of homestead assessment difference, and that's DR-486 capital P-O-R-T. Withdrawal of petition, and that would be DR-485WI. So those are some of the things now that I just cited. Those are forms that you would look up, and you're going to want to look up for the ownership, which is, I'm afraid I don't have it on here for some reason, but that is you're going to look for the form, and you're going to fill it out as to claiming ownership on your property, and you should be able to see that when you go to your website. Now we're going to go into a little bit of history, and this also has to do with what Ed has been talking about, in fact, quite a few of us. So this has to do with something they don't want you to know. This is something that I believe Ed will catch on when I start to read it because he is aware of it. This has to do with the trust. and where we stand as pertaining to the trust. Now keep in mind, this is something that I looked up, so please check it out for yourself and make sure that what I'm claiming I might be right. So don't just take it upon me to, in other words, there might be something here that might not be correct and that I might not be aware of, but so far from what pardon? Yes.
On the site, you mean, or on the show? Okay. I'll post it up here just a second.
Correct. Oh, would you like me to say it? I can say it. I can say it. I'm not an attorney, so I am not giving you legal advice. This is something that I looked up, and I would like for you to look it up yourself. And it's something that I found off the internet, and as me looking up laws and statutes. So this is just my opinion. I'm not giving you legal advice, so please look this up as to what I'm going to be reading to you, and this has to do with the trust. It's called I'm not sure how to pronounce it. I'm going to say Conveyances Trust is how I would pronounce it, and that would be CES-TUI and then Trust, QUI, and then Trust, pronounced as Sedekey, is how they have it in the diagram when you look this up. So when you type in your Google search bar, if you type in, I think it's pronounced Casta Quove Act, and that would be 1666. You will pull up the document that I'm going to read to you as to what I'm giving as my opinion. So I pronounce it as Quove Trust, or the Quove Act is what you would put in your Google search bar, and that would come up under the year 1666. So in 1666, in London, during the Black Plague, the Great Fires of London, Parliament enacted an act behind closed doors called the Quove Act of 1666. Now this document is a public record, so I'm sure it has some truth to it since it is a public record, and believe it or not, it is in the websites when you cite statutes and codes as to the laws. So there must be some truth to it. The state of London took custody of everybody and their property into a trust. The state became the trustee, husband holding all titles to the people and property until a living man comes back to reclaim those titles and can also claim damages, meaning you are going to court as a fiction, but you can claim your title when you go back to court, and you can claim damages when you know that you have fallen under the statute as to the trust, meaning the property into a trust. This is what Ed's been talking about to you guys and trying to explain that to you over the phone or at these meetings. The rule of the use of capital letters used in a name. When capital letters are reused anywhere in a name, this always refers to a legal identity, fiction, company, or corporation, no exceptions. E.g., John Doe or Doe Jane, passport, driver's license, marriage certificates, and birth certificates. So what I'm talking about pertains to your fiction side. Hang on, I've got to switch phones. My phone was, excuse me, my phone was going to go dead. Okay. So what I'm talking, yeah, sure.
This all goes to identity theft.
Absolutely. Now I'm going to explain why. The reason why this is because it also goes to the jurisdiction pertaining to the courts. Because remember, what did they do to you? They brought you into their jurisdiction when you got the summons pertaining to your foreclosure, right? But they didn't give you the opportunity to represent yourself under a grand jury. Remember, we fall under a common law or a grand jury under natural law. So what they did is they violated your due process rights. Keep in mind, because I got so well at looking at this material, what I'm sharing with you, I actually petitioned and I challenged the courts. But you have to get educated to know what you're talking about in order to do that, and I did. So I actually challenged the court, and I put them on notice that I never consented to the taking because they addressed me in the wrong jurisdiction. So this is why I'm going over this document with you, because this is what Ed is trying to explain to you as to them addressing us under our fiction. That is why our senators and our governors have addressed a driver's license and a birth certificate. They wanted to put us into a trust. That's why when you go into court, the judge is the trust until you say your name. Now that what happens is the judge is reversing it. He is now not the trust, you are. So you have to understand how that works in court. So once you realize how that plays out, you can't be fooled, and the judge will catch on to that. There was a verbiage that I wanted to cite. Unfortunately, my computer was giving me some problems, but there is a statement that I had found on my document. I was going to share that with you tonight on the phone, so I'll have to share that statement. But what it is it's a simple statement, and when you make that statement, what you're doing is you're claiming the trust, but what you do is you throw the trust back to them. Because what the judge is doing is he's putting you under the trust, and then you're reversing it, and you're putting the trust back to him. But I lost that statement. I'm going to see if I can find it while I'm going through this information. If you're willing to listen to what I have to say, I'll probably come across it in my verbiage as to what I'm reading, because I'm sure it's in my document here. I just had it off to the side, and I wanted to cite it. So what I'm basically explaining to you is your fiction side. This is what's called a quasi trust. And you can Google it. Like I said, it's called a Quasi Act 1666, 1666. If you Google that in your Google search bar, you will find this document, and you'll be able to read it at your leisure, what I'm talking about to you. And it's about, I'll tell you, it's about 11 pages or 9 pages long. And I actually do have I do have it because I took notes because I had to represent myself in court. So I do have it, and I'm going to skip over stuff, and I will read that. I will find that phrase. I have the document. So I'm going to go over this. But what I wanted you to understand is this act goes all the way back to before Jesus even was heard of, because this is what Jesus was referring to when he was citing his disciples, okay? What Jesus was doing is he was trying to teach back then now what was natural law, because the law was already written before Jesus even came about. That's why when our foreign fathers wrote the Constitution, they added only the 10 Commandments. That's why in the 10 Commandments, those were our God-given rights pertaining to God. There was no religion, and there is no religion. No, religion is not supposed to be brought into the courts, and just as they are doing now, they're using religion against us. By brainwashing you, thinking that in other words, they're claiming a religion. That's their way of fooling you by bringing a claim upon you as you being deceived by Congress, by our president, the governors, and state senators. They all know this. This goes back many hundreds of years ago. That's why Jesus used the word pagan, a pagan government, meaning the sun god. Now, those that are Christians, I'm sure you probably heard of the sun god. The sun gods are the temples that are on top of the churches, believe it or not. We've been fooled by many, many enemies, all right? You haven't been taught properly from the church. You've been deceived in many ways. Again, that has to do, and the reason why that is because they want to address you under a fiction. They don't want to address you as a living being. It has nothing to do with faith as a religion, meaning you being Catholic, whatever. It has nothing to do with that. It has to do with trickery. So this is why a lot of people get offensive, because they're being misinterpreted, and they're thinking it has to do with religion when in fact it does not. So you have to understand, I've done a lot of research, I've done a lot of reading pertaining to our history. I've gone all the way back to the 1300s. So what Edward is talking about, he's correct. It's finding the literature in order to share it with people so they understand and comprehend what you're trying to say. Otherwise, it's like you being a surgeon, okay, and you're trying to teach heart surgery to somebody that has no idea how to do heart surgery. It's all, like they're not going to understand. Until you put the puzzle together and you do your research, then you'll see the puzzle. That's why I was so distraught for a long time, because I realized how I was being deceived. And you have to understand, a lot of our lawyers and attorneys, including our judges, do not know this. They are not taught that. They're only taught what they need to know and what they want them to know, and that's it. It's the same scenario as our children today. They don't want us to know these things, and they don't want our children to know these things. It's very important that you understand this. That's why we are going downhill. Oh, before I finish reading this, another thing too, and this is very important for those that are addressing foreclosure. Freddie Mac and Freddie Mae are the biggest bailouts in history pertaining to the United States of America. They are the ones that took us downhill. They cause a lot of problems, and they have put us in jeopardy due to us facing the money as us being in default. That's part of it. And remember, the Democrats at that time, meaning our president, which was Obama, he bailed out the banks. The reason why these banks are now addressing these fraudulent claims regarding foreclosure is because of the lawsuits and because of Freddie Mae and Freddie Mac. Now you can find a lot of this information out by going to C-SPAN and just listen to them talk. I listen to C-SPAN, and I actually listen to those that are in office, meaning in Chamber of Commerce. If you go to their websites, you will hear the truth because they're the ones talking. See, I don't listen to people talk and go by hearsay. And by the way, that's also something that they use in court. They go on hearsay. Well, hearsay is inadmissible. Remember, you have to prove the facts in court. That's very important, okay? So what they do is what they have done, meaning our meaning Congress, our government, our state senators, okay, and our governors. They have put us under a trust. And this is what I'm reading to you. That's why they came up with the fraudulent driver's license, the birth certificate. Remember, and this wasn't that far back, when we were born, you were given a live birth certificate. Those live birth certificates were put in Bibles. They were not given back to the government. Those live birth certificates were put in a Bible, and your mother and your father kept those records at home. They were not shared. They were only shared to those siblings of that family, and they were passed down to one another as a tree, the family tree of record. But we have been so deceived and so misled, it's unbelievable. Remember, this goes all the way back to the biblical times. Many things, history repeats itself. Just look at history. And the symbols regarding the sun gods. If you even look at cave drawings, there are symbols. Now, these symbols under the sun gods, you have to learn that. So you'll have to do a Google under sun gods. What are sun gods? If you put that in your Google search bar, you will find that history pertaining to sun gods, what the symbols are and what they represent. So you have an idea what you're looking for as symbols. These are symbols. For instance, they use a pine cone. The pine cone has a meaning. Remember, our English language has been so diminished that if we were to go back in their time and read English, we would not know what the heck we're reading. That's how bad we have been dumbfounded. I'm not kidding, because it's the same thing like if you were to read the actual documents pertaining to the Federalist Papers, you would be shocked. You would have a hard time understanding them. They did that on purpose. Okay, so let's go back to where we are. So if you type in, this has to do with your fiction, and once you learn this, okay, which falls under the Reclaim Using Act or the Reclaim Using UCC 1 and the PPCA, okay, regarding damages. This has to do with the state of London took custody of everybody and their property into a trust that even includes your property. You are the property, the labor, okay? Your labor is the property, meaning you. Your labor is property. Your only way out is to reclaim your dead identity, the straw man, that the Crown created, became the trustee of the became the trust of the, I want to say it, Casto Quo Trust, CESTTUIQUI Trust. And you have to remove yourself from that admiralty law that holds you in custody. You can claim your body any time. It doesn't have to be a lawsuit. When you know this, you can actually claim it. You can actually go to probate court and claim it. A lot of people are misinformed under that, but you can claim it any time. Same with the taxes. You can claim it because it falls under the same scenario as identity theft and your Social Security. Okay, I'm gonna skip over a lot of the reading on that because you can actually Google it and read it yourselves. But what I want to go is I'm gonna skip to the areas that I highlighted for my own use, and I'm going to try to find them and share them with you because this has to do with the court. Because that's a several-page document, and we don't have time to go over the whole thing. When the name of the trust, IG, like John Doe, is called by the judge, a.k.a. administrator, aka trustee. Remember, I told you that the judge is the trustee. We can stand and ask, are you saying that the trust which you are now administrating is the John Doe Trust? When you say that, I'm going to tell you right now, the judge is going to not like it. He knows now that you educated yourself. This establishes that we know that the name is a trust, meaning your name, not a live man. What's the JAT's first question? What's your name? What does the judge ask you when you go to court? What is your name? And the reason why he asks you your name is because he wants to convert it. He wants to make you the trust. And you say, this is I lost my line. What is your name? Or state your name for the record. We must be very careful not to identify with the name of the trust, because doing so makes us the trustee. What does this tell you about the judge? If we know that the judge is the trustee, then we furnished, I lost my line. Lost it. Hang on. Sorry. Bear with me. Darn it. Let me go back to the top. I lost it. I'm sorry. Let me get a piece of paper to help me so I don't lose my line as I'm reading. Okay, let me start over. I'm sorry. When the name of the trust, e.g. John Doe, which is in all caps, is called by the judge, a.k.a. administrator, a.k.a. trustee, the GAT meaning the judge, we can stand and ask, are you saying that the trust which you are now administrating is the John Doe Trust? This establishes that we know that the name is a trust, not a live man. That's the JAT's first question. What's your name? Or state your name for the record. We must be very careful not to identify with the name of the trust, because doing so makes us the trustee. What does this tell you about the judge? If we know that the judge is the trustee, then we also know that the judge is the name, but only for this particular constructive trust. Now think about all the times that the JATs have become so frustrated by our refusal to admit to being the name that they issue a warrant, and then as soon as the man leaves, he is arrested. Oh my God, I hate that when I come across a word and I'm tongue-tied. I can't say it. IDIOTIE. Ironic, thank you. Is that they must feel foolish for saying John Doe is not in court, so I'm issuing a warrant for his arrest. And then the man whom they just admitted is not there is arrested because he is there. Their desperation makes them insane. They must get us to admit to being the name, or they pay, and we must not accept their coercion, or we pay. So in other words, what they want us to do is say our name and give consent. When you don't consent, remember, you don't fall into their jurisdiction. Therefore, they can't make you the trustee, and they can't make you pay. That's why they ask you, what is your name? So before you say anything and before you answer to the judge, you say, I'm sorry, for the record, I do not consent. And then you go on to say that you're there under natural law. You don't have to say you're there as a live, breathing man. You can just say I'm here under natural law, and I don't fall under your jurisdiction. I don't consent. That's all you got to say. During their frustration over or not admitting to being a trust name, the trustee and or executor of the trust, meaning the clerk of the court, we ought to ask who they are. Before we go any further, I need to know who you are. Now, this is you, of course. Address the clerk of the court, the trustee for the CQV trust owned by the state province. Are you the CQV trustee who has appointed this judge as administrator? By the way, this is very crucial. This is what I'm reading to you right now are your key elements, what you would say in court. This is what I have highlighted, okay? So you can look on your Google search bar, and the abbreviation would be CQV trustee, okay? I'm going to read that again because this is very important for you to understand this. During their frustration over or not admitting to being a trustee name, the trustee and or executor of the trust, meaning the clerk of the court, we ought to ask who they are. Before we go any further, I need to know who you are. Address the clerk of the court, the trustee for the CQV trust owned by the state province. Are you the CQV trustee who has appointed this judge as administrator and trustee of the constructive trust case? And of course, you would name your case number as being what you're going under pertaining to your case number in court. Did you also appoint the prosecutor as executor of this constructive trust? Then you point to the judge. So you are the trustee. Then point to you, also appoint to the prosecutor as executor of the constructive trust. Then you point to the judge. So are you the trustee? Then point to the prosecutor. And are you the executor? And I am the benefit. So you have to understand, you're claiming now you're going to be the beneficiary. And I am the beneficiary. So now we know who's who. And as beneficiary, I authorize you to handle the accounting and dissolve this constructive trust. I now claim my body, so I am collapsing the CQV trust, which you have charged, as there is no value in it. You have committed fraud against all laws. Likely you will not get any further before the judge will order case dismissed, or even more likely, the PE as he clings tightly to his Crow book will withdraw the charges. So you have to understand when you cite this in court, just like I was reading to you, you have now become the beneficiary. Remember, they didn't want you to become the beneficiary. They wanted you to be the trustee. So when you claim yourself as a live person, you are the beneficiary. And if you do just as I read to you and you make that statement to the judge, that judge is going to freeze. Because that judge is not going to be expecting you to know that. So that has to do with your fiction side and you claiming your live body. Okay? That's what that's all about. Now I'm going to go back. I'm flipping over pages because, like I said, we're going to move on. Foreclosure. This is under foreclosure. The clerk is the senior, I can't say the word, bear with me.
Michelle?
Yes. I'm going to spell the word. I can't say it. I'm tongue-tied for some reason, but this is something that they need to know. So I'm going to spell the word.
No, I know that. In about 15, 20 minutes, we're going to do some Q&A answers, so go ahead.
That's fine. Now, this has to do with, this has to do with the mortgage. This has to do with you as you being a tenant, okay? And how, so anyway, let me read this. I can't say it. It's acquisition. I can't say the word. I'm sorry. The clerk is the superior, and I'm just going to spell the word. ECCLESIASTICAL officer, and can assign the title over to the bank. We are tenants. The mortgage is the lien or lease loan. We do not and cannot own anything. The bank does not want us to pay the mortgage, which is the interest, aka rent. Because they want us to be delinquent, i.e., incompetent in performance, which is the main point of the contract, in order that we lose our claim. When we pay some form of rent, even if only $50 a month, we change our status from delinquent to competent. And this allows us to remain honor, which is the entire matter. They do not want us to behave honorably. The bank court cannot force us to leave property, yet we must address our standing. Then we can use their procedure against them. We must challenge the CQV trust. If one gets to court, RE, foreclosure, as a tenant in this matter, with only right of use of property, I ask for a stay as I haven't exhausted my administrative options. We can do this in order to buy time to, back to that word again that I just spelled to you, which is a deed, pull, as in abbreviation, EDP, an original issue, through the clerk, prematory trustee of the CQV trust, or the chaplain of the court. They must forgive opinion court, or they have lost their, how do you say that? ECCLESIASTICAL. How do you say it? Essential authority. So this is why they don't, when they address the paperwork and the banks, you have to understand, this is why they are addressing your debt. Because remember, they fraudulently made a claim upon you under identity theft. Because what did they do? They based it on your taxes. A lot of this pertains to taxes. Has nothing to do with your mortgage payment. What they did is they filed a lien upon your property. Now, if you were in default on your mortgage, it's very crucial that you can show that you were trying to make a payment, even if you are in default. Because if you're trying to show that you were trying to work with the bank and you were making a payment, that is in good faith. A lot of people that were addressing some of these older calls, I'm not talking about this call, but other issues, were trying to get a free ride. In other words, they were trying to steal a home from the bank, knowing that the banks had violated their rights and made a fraudulent claim. But in order to do that, you have to make that proof of claim before you stop making payments on your mortgage. Because as soon as you stop making payments on your mortgage, what you just did is you opened the door and you gave them the opportunity to show cause. If they can show cause, and they have evidence to show cause, well, they're going to win. It's the same thing like I'm telling you. When you file your claim, you have to have evidence to prove your claim. If you have evidence to prove your claim, you're going to win. It works both ways. So that's very important that you understand that. But now remember, we are talking about identity theft, because what the banks did is they deceived us at the very beginning when they addressed the contract, and that goes back to the adhesion contract under law. That's why it's important that you understand and you learn these things, and once you learn those simple things, then you can move forward and you can file a notice to vacate. A notice to vacate is those who have gone to court already and have lost their cases as hiring and paying out money towards your attorney's fees and costs. Because fraud, there is no statute of limitation on fraud. So it's very important that you understand that, and don't let them tell you otherwise, because that's what they think got you thinking. There is no statute of limitation. Now, when you take your case to court, you're going to cite those statutes that I went over earlier, which is under Title I, Section 201, Section 202, and so on, okay? And Section 20, it goes all the way through 205, I believe it is, regarding that code. And that is, what you're going to do is you're going to look at your mortgage statement. And believe it or not, now we're going to talk about the instrument. And this is what is very important. Because once you understand how the instrument works, it is a check of value. But they didn't address the banks didn't address value when you sat down with the title company. The title company and the banks committed fraud upon you at the very beginning of your case. That's why a lot of people didn't want to make any more payments on their mortgage, because they discovered the fraud. But what they didn't understand is when they stopped making their payments before they took the case to court, they opened the door and made it where their enemy, who they're up against, is going to now file a lien against your property for you not making a payment. What they should have done is taken the claim first to court before they stopped making a payment. Because you can declare under fraud, anytime there's fraud, you can remove yourself, and you can also remove them as bringing a claim against you. And that is another issue that is amongst my papers, of course, that we can touch on, but those are just little things. And by the way, that also falls under the Unfair Act. So there's a lot of things that you have to learn regarding certain things as to what I'm talking about regarding fraud. And what you do is you just Google under fraud in your search bar. You'd be amazed what you'll find. Oh, and by the way, you would address adhesion, intrinsic and an intrinsic fraud, and or extrinsic fraud. Those are all fraudulent claims as to what's brought up on the court. When you can prove intent that they brought you into court on a false claims act, you will win. And you can file that on a motion to vacate final judgment on your foreclosure, even though you went to court and you lost your home and they sold it, because they did it they deceived the court. It's a very serious crime. And it also comes into place, even believe it or not, under treason. So there's many things that pertain to that, and that's why they don't want us to bring these cases into court. That's why these attorneys and these lawyers, it's a scam. Oh, I'll take your case. Sure, you'll win, no problem. You pay your attorney $20,000, $25,000, even up to $50,000. Oh, I'm sorry, you lost your home. It was all a scam. when they knew that they were violating your rights, and they knew that they weren't addressing the court properly, and the courts sat right there and knew that they were addressing an adhesion contract against you, et cetera, et cetera. I mean, because after all, they did break contract law. But you have to learn those things. And this is what they don't want you to know, and and you have to learn these things. Hang on a minute, I'm looking up some things here as to a debtor. What is a debtor and a creditor? Because I know some people get confused on that. Those that are in foreclosure, you are a debtor, and they are the creditor. The debtor-creditor law governs situations where one party is unable to pay a mandatory debt to another. There are 3 types of creditors. The first are those who have a lien against a particular piece of property. This property or proceeds from its sale must be used to satisfy the debt to the lien creditor before it can be used to satisfy debts to other creditors. A lien may arise through statute, agreement between the parties, or judicial proceedings. CEG, secured transactions, and mortgages. Remember, we're talking about also transactions, and that's another scenario that we'll go into. The secondly is creditor may have a priority interest. A priority arises through statutory law. If a creditor has a priority, his debt must be paid when the debtor becomes insolvent before the other debts. For example, Congress has granted priority to debts owned the federal government. See Federal Tax Lien Act. By the way, that is another thing now that they are doing, and it's advertised on the internet, and I'm sure many of you have seen that, where you've seen advertising under the Tax Lien Act. What they want you to do now, and you can do this, by the way, and it's legal. You don't even have to go to court. What you can do is you can look up someone's taxes, right? And what you can do is you pay their taxes. Now remember, the party involved has to be behind 2 years on their taxes before you can make a claim. And you have to pay on their taxes for 2 years before you can act. So this is something new now that they're doing. Because your mortgage might be paid off in full, but let's say you're 2 years behind on your taxes. How would you like it if I came along and I paid your taxes for 2 years? Guess what? Now I'm going to move forward and I'm going to file a lien against you because I paid your taxes for 2 years. That is the same scenario what we're talking about as of today regarding the transfers. Same fraud. And they're proud of it. Aren't you happy that they're proud of this? This is our state senators and our governors doing this to us as we speak of today. Educate yourself, and by golly, if we get together and we file claims against them, that's why I want you to file the document pertaining to you going to the property appraisal. This is going to stop it. As soon as you file that document as ownership with your property appraisal, even if you're not in foreclosure, I'm asking you to do this. It will put a stop to them losing your homes, to them paying your taxes. Because in that document, you're going to say, I do not consent to any other actions depending on my property without consent and without being notified or verified. So even if you don't have even if you don't have a mortgage, your home is paid off in full, you're going to fill out that form. This is one of your key elements that I'm trying to explain to you, because once you're in court, you only have 30 days before they take possession of your property. That's why they have to put a short sale and they have to advertise it in the newspaper. If you don't address that document and notify the property appraisal's office that you are a victim to fraud as to identity theft, and even if you're not a victim to identity theft, you're going to say any further actions that come up upon this home under my name is I don't consent to the taking. Once you do that with your property appraisal and you fill out those documents, and aren't they going to get a surprise? Because we, the people, woke up. And that's what they don't want you to know. That's why they don't tell you that when they take you into court, when you get your summons. They make you answer to the summons and they take you into court in violations of your due process rights. They address you under their jurisdiction when in fact you should have been addressed not under their jurisdiction but under a jury trial. Oh, and that's another thing. When you petition the court, you're going to request for a common law grand jury. You can pick your own peers to review your case. That is very crucial. You're not taking your case in front of the judge per se. You're going to go in front of the judge, but you're going to have the grand jury review your case. That takes the whole scenario away from the the judge. Judge can't intervene. They don't want you to do that. That's why they're taking us in court under the wrong jurisdiction. And by the way, when you get good, you can actually challenge them. You can do like I did. Challenge them. Petition them. It's not all that hard. And let me tell you, when I took my papers into the courtroom, that judge looked at my 3 documents, which, by the way, later on I will be sharing with Ed. I will share my documents with you. If you really want to do it, you can. It's not all that hard. Because once you get them in the corner, I'm telling you, they don't know how to act. And they have made so many mistakes. Holy cows, it's unbelievable how many mistakes they make. Number 1, you want to know what the first mistake was? Their electronically filed document. Remember, what did they do? They filed an electronic document. Right? Think, it's all about common sense. They stole your identity. Okay, they addressed your Social Security without your consent. They addressed your taxes without your consent. The federal agencies pertaining to the taxes even violated the laws. That's why I have them shaking right now, because I told them I know I broke the code. Once they realize you broke the code, they're going to be scared. They're not going to want to take this into court and make a big thing out of it. They want to keep it very quiet. That's why you don't hear things on TV who won their cases. They don't want the media to know. They don't want, because think about it. How does that look? You're not an attorney, and you take your case into court and you prove that they committed a crime upon you under identity theft. Do you see how that looks? And then you have the Bar Association who's in on it, who's by the way, like with my case, I have lawyers and attorneys. Hell, they've even have already been indicted, and they're still doing it. I have one attorney that doesn't even have an office. He's using a P.O. box number. He's not even registered as an attorney. It just goes to show you how deep this fraud goes. We have many agencies involved. They're all in on it. Okay? Remember, this goes back to Freddie Mac. It even goes back to our president. Remember, what did that president do? He bailed out the banks. So this is why they don't want you to know what I'm teaching you and what I'm bringing forth upon you. I'm actually kind of nervous because I don't want to jeopardize their the federals, because they're going federal with my case. You have to understand, I'm speaking for you. When I go to meet with the IRS gentleman, who's the special agent now, I'm putting him on notice. And my notice isn't going to be very nice because I'm going to make a request. I'm putting them on the spot. I'm also putting my life on the line, but I'm going to do it. I'm gutsy enough to do it. And I'm going to let them know there will be no more foreclosures, period. You're going to address a memorandum, and they're going to initial my document. Now, I ask that you don't say anything. This is on this call. So those that are listening to me, I ask that you keep your mouth shut. Don't jeopardize my case, because this is not only for me, it's for you. I'm putting my life on the line for you. I've done my homework, and they know it. And they know I broke the code. I know exactly how the banks are doing the fraud. I know who's who, what they're doing. I'm not going to tell you right now because I don't want to jeopardize my case, but I broke the code. You can break the code. Once they know you broke the code, and we all start filing our paperwork, and we let them know that we know how they're committing the fraud. We know who they're sending the documents to, what bank's doing what. Once you do your homework, I'm telling you, it's not hard to do. You have to study. You have to get copies of your bank statements. You have to see who's endorsing your checks. You have to get a payment history on your taxes. You have to see who endorsed those checks when you paid your taxes. You're going to be amazed.
Mm-hmm.
The Homeowners Association, they're in on it. You have to see who's endorsing your Homeowners Association checks when you made your payments to the Homeowners Association. See who's endorsing those checks. It's very important. That is your evidence. When you put that together, you have them. You're going to win. There's no ways around it. You're going to take that evidence then, and you're going to file a criminal complaint with the law enforcement. You're not going to go into the law enforcement and say, oh, I filed a lawsuit. No. I'm a victim to identity theft. I have a serious problem, and I just don't know what to do. Those are going to be your words. And then you're going to say, well, here's what I gathered, and I just don't know how to do this. What you have to understand is you have to play stupid. Don't go in there like you know it all. Play stupid, man. I mean stupid like you're retarded. Third grade level, second grade level. Cry. Oh, my God, what do I do? I'm losing my house. Look what I discovered. That's what I'm talking about. How do you think I got where I'm at? How do you think I got the evidence where I'm at? Because I played stupid. I even played stupid with the Attorney General to get where I'm at. You have to understand. You have to trick them to get things. You don't want them to know that you don't want to let on what you know with your enemy. Oh, and that's another thing. Those that lost their homes and their homes have been sold, what I want you to do is try to find out who the real estate was. If you can find out who the real estate was, you can go into the records. In fact, it should be an easy find because all you have to do is put your address in their database like you're looking for a house to buy. There you go. Bingo. Once you get that info, guess what? Now you move forward. Now you call the property appraisal office, the deed, right? And you're going to ask them, who owns that property? You got to get those names. You got to write them down. That's your evidence. That's what I did. You get their names. You're going to apply that information to your identity theft police report. That's what I did. When I went back, you have to understand, I was turned down just like you were turned down. I know you're frustrated and you're angry and you're disgusted and you think you've lost. You haven't lost. You have to do your homework. All right? I know how you feel. I lost my home too, but I kept at it, even though I went to court. You have to understand, it's all live and learn. I went to court many times. And where I failed is I didn't know what to say because I had my paperwork done, but I didn't know enough how to react when I was in court. In other words, when the judge was pinning me up against the wall, I wasn't sure how to come back. And that's where I failed. And then I woke up. Oh, now I know what I need to do. It's all trickery. It's all acting. And you have to be very blunt, and you stand firm. And you just come right on. You tell that judge, well, I'm putting you on notice. And I did. I put that judge, let me tell you, when I put that judge on notice, oh my gosh, I wish you could have seen her reaction. Because now she's like, oh, you're putting me on notice? See, it's a whole different scenario when you put them on notice. Because now you're telling that judge, you're holding them accountable. Remember, it's all about after the fact. So those that lost their homes, remember, you have punitive damage. You can claim punitive damage by filing now your motion to vacate. And you can reopen your case just on that alone. And guess what it's going to be on? Identity theft. You're going to address an identity theft claim. Remember, now I'm saying if you go to court, that means that you're having... Yes.
Let's do some questions and answers. If anybody's got any questions,
sure, absolutely. Let me just finish. Let me finish my statement because that's where I was going to leave off, and then we can open up the floor. But what I was going to say is those that, when I say address the court, I mean that when you filed your police report with the police department or the sheriff's department, and they're not taking criminal action as to reopening the case criminally, what I'm saying then is you're going to take it into court civil under fraud, and you're going to address identity theft. But normally, if you're really good at it and you do your homework and you file identity theft complaint with your police department, they have to act on that. Once you can show proof, then see, you don't have to do anymore. It now falls into their hands. They take it into court. And that's how my case came about, because I proved without a shadow of a doubt that I had evidence to back up my claim. They had no choice but to reopen it up and take it. The Attorney General took it. The Attorney General stood me up. Now it went back to the criminal investigator, and now they're taking it federal. And I mean, they're not joking. I have 3 huge folders from A to Z that I put together. They are not happy right now because they know I broke the code. Okay, I'm going to yield and give the floor back to those that want to ask questions.
Any questions out there?
Thank you very much, Michelle.
You're welcome. There is one thing that I'd like to touch on after questions, and that's about the U.S. Marshal. That is the last thing that I was going to bring up, and touch on a few things regarding the Federal Tax Lien Act. Other than that, we can, if there's any questions, feel free to ask me those questions, and I will cite the statutes under certain things that are opened for me to see that I can give to you while we're on the phone.
Yeah, I don't see anybody speaking up, so go ahead and continue, seeing that nobody wants to jump in, because you're walking through it with people, so go ahead and continue, because this is what everybody needs to pay attention to, because it's your responsibility to save your home. It's your responsibility to save your children.
That is right. Now,
if I may,
I'm going to cite some. I'm going to.
Hold on, Michelle.
We might want to let the listeners know that they need to hit ** in order to get unmuted if they want to speak.
Oh.
Good point.
And I
yeah, that does sound like a good one.
So yeah, that's what.
Well, if no one has a lot of questions, then I must be doing a good job as to what I'm talking about, and where they're understanding things. Now, remember, I'm going to, before I cite some statutes and codes and under federal statutes as to where you stand, I'm going to cite some, so don't worry, because this has to do with where I'm going as to the next discussion, and that has to do with the banks and the banking and the rules and the regulations. So I'm going to cite those and you can write them down, and I will even give you the websites. So I'll reveal that. One of the things that I want, and that I'm going to go over again, which I brought to your attention last week, but I'm going to repeat myself for new listeners for this week. And that is the Uniform Fraudulent Conveyances Act. And of course, that has to do with the states and adopting the Uniform Fraudulent Conveyance Act as to fraudulent transfers. And of course, that also will apply to bankruptcy. If anybody, if they did lose their home and they had filed bankruptcy, that would be in violations of Rule 11. So if you were in bankruptcy, because I know that was one of the tricks that they played into, as you being the debtor and they being the creditor, because that is one of the things that they wanted us to do, is they wanted us to file bankruptcy. And the reason why they wanted to file bankruptcy is because, after all, they wanted to file a lien. That was their way of stealing your home. If you had a discharge, that is very crucial to understand. If you had a discharge after filing a bankruptcy act or claim upon the court, they cannot sue you. And another thing, banks cannot take your property. And that's exactly what they did. The bank cannot take possession of your home. It has to be an individual party, a lender. Now, what the banks are claiming when they took you into court, they claimed a lender. Well, that lender is fraudulent. Now, maybe in some cases it's not fraudulent. I don't know that. The only person that would know that is you. And the only way you're going to know that is by looking at the contract when you bought your home. You have to look at your mortgage. You have to ask for a copy of your HUD, which is part of the payment history on your mortgage. You can get that information and those documents through the deed holder, who's ever the holder on the deed pertaining to your property, through the property appraisal's website, through your county, or maybe even going to probate. You might be able to even go to probate and ask the probate court to help you as to claiming your property. These are just little things you can do, very simple, that will help you find out that information, because I know some people are having a hard time finding out who owns their contract as to the mortgage. Well, public record. You got to go to the public records county and look for those records, and basically it's a very simple move. All you do is give them your address and boom, there it is. There's ways of getting your documents without knowing who is actually holding them. It's a public record. So I don't want you to think that you can't get your documents. That's not true. So the property appraisal's office will give you the runaround. If they know that they're dealing with a fraudulent claim and they are part of the fraud, they will give you the runaround. They'll tell you right bluntly, well, you know what, I don't know who owns them. I don't know who owns your documents. Or they'll give you another excuse. Well, that they went under. They're no longer in business. That's another excuse they'll give you. They'll do anything to stop you from moving forward, especially when they know that you know you're a victim to fraud and identity theft. They'll do everything in their power to stop you from getting your documents. The federal material, the U.S. Constitution and federal status, the U.S. Code, the Federal Tax Lien Act, which is, and you want to write this down, is 26 U.S.C. Section 6321. And that website is www.law.cornell.edu/WEX-CGI WEX link, LINK, with a question mark. The Fair Debt Collection Practice Act is 15 USC section 1692 www.cornell.edu/CGI/WEX link question mark WEXNS, the two little lines like a space, capital USC and WEXNAME, the two little lines, space, 15, and then chapter 41. Was that long? It's unbelievable, some of these websites. The Consumer Credit Protection Act, the Consumer Credit Protection Act, 15 USC, section 1601. It should take you right to these websites under the law, which is the law, Cornell's educational website. The CRS audited Constitution, and that's www.law.cornell.edu/ANNCON/search SEARCH.index.html question mark. Inquiry, lien, +, at, +, collection, +, or, +, consumer, +, or, +, debtor, +, and, +, credit. The federal agency regulations, which is what we fall under, pertaining to our natural living rights, okay, believe it or not, falls under the banks and banking system. That law is the Code of Federal Regulations, and that is 12 CFR C.F.R. Website www.law.cornell.edu/CFR/CFR.php question mark title space with the two lines together 12. That stands for banks and banking. 16 stands for commercial. 16 CFR website www.law.cornell.edu/CFR/CFR.php question mark title space with the two lines 16. 12 stands for banks and banking. 16 stands for commercial practices. Federal judicial decisions. The U.S. Supreme Court. Recent decisions on debtor and creditor law. You can put in your Google search bar recent decisions on debtor and creditor law, and you will come up with the website www.law.cornell.edu/SUPCT/search SEARCH/index INDEX.html question mark inquiry dash with the two lines and then a percentage sign 2, the number 2, not the letter 2, but the number 2. Excuse me, it says 28, so it's a letter, the number 28, lien, LEN, +, and, +, collection, percentage sign, 29, +, or, +, percentage sign, 28, percentage sign, 28 again, consumer, plus, or, plus, debtor, percentage sign 29, and plus sign credit percentage sign 29. This is bulletin oral argument previews. Again, the website would be www.law.carnell.edu/CERT/index.html ? Space with the 2 lines, percentage sign 28 lien plus sign, and plus sign collections percentage sign 29 plus sign or plus percentage sign 28% to 8 consumer plus sign or plus sign debtor percentage sign 29 and plus sign credit percentage sign 29. Holy macros. Was that long enough? I mean, geez, I can't get over how long these those websites are. Now I'm reading off the websites, so that way when you do your Google search, you have an idea what to look for. So that way, if you're not sure, you can say, well, geez, she read it off to me. This kind of looks like it. You have an idea. State and judicial decisions, that would be New York Court of Appeals. That would be decision on debtor and creditor law. You can Google that. You're going to come up with the same email under, which is the law Carnell Education EDU / New York CTAP search index. Well, it would be search/index.html ? The same with inquiry, okay, liability, and So, in other words, once you Google just the state's judicial decisions under New York, you can do the same under other states. Just put state judicial decisions, put your a comma, and then your state, and it should just come right up, okay? Other referrals, we don't need to go on that. Other topics, we don't need to go on that. So that's it for that. Now, under Chapter 713, Bankruptcy Attorney Protection Form, Debt Collectors. Again, you would have to look up those statutes. Unfortunately, what they do is they right away when you put out in those search bars for those things, they want to refer you to attorneys. They don't want to refer you to the info. Because after all, they want to keep you dumb and stupid, and they want to keep you incompetent. You want to be competent. You don't want to be incompetent. Oh, and just so you know, there are many lawyers and attorneys that will help you with your paperwork. They will help you with your case, and you can tell them that you want to represent yourself in court, that you only need them to assist you in addressing your documents if you're not sure. I've had many good lawyers and attorneys who you have to pay for it, of course, but they will do that for you. They will help you because they were willing to do it for me. Because a lot of them will give you that opportunity because remember, when you do it, you're not in other words, when you do it, you are doing it of your free will, and it also opens the door to giving you extra maneuvers that a lawyer cannot do. Because remember, they are part of the Bar Association. So they're willing to help you when you have a fraudulent claim. They're willing to actually help you to do that because you're giving that attorney or lawyer the opportunity to help you. And because he knows he's not up against the Bar Association, meaning his peers, it actually gives you more of an opportunity because there's different maneuvers you can take. Because remember, you're not a lawyer and you're not an attorney. That judge cannot address your case under the same standards as a regular lawyer or an attorney. Gives you more opportunity to address the court and take further action, if that makes sense to you, because you're not trained. You're not a bar. You're not a lawyer. All right, I'll stop there. I don't think I need to go into more definitions unless they want me to. I can go on to more definitions, but I pretty much have covered everything that I wanted to say. So I will yield now, and I will open up to questions.
Michelle?
Yes.
Michelle?
Yes. Can you hear? Can you hear me?
All of these Cornell University websites that you quoted, do you have these on your website?
I don't have them. I don't at this time. I don't have all. Well, I have some of them on my computer. What I can do is, and this is what I'm doing now. What I'm doing is I'm scanning my documents into my computer, and then I'm forwarding them to people like who need help. So that is what I'm fixing to do now. So if people are having a hard time getting this information or finding these documents, I will share them by email, and I will try to put some of them in a note on Facebook. The problem is I've noticed when I post things like this under a note and I share it on Facebook, unfortunately, they don't want this info to be out there. So what they do is they don't allow the person to see it. But I think there's ways around that. If I just share it as under an instant message without posting the link on my website, on my wall per se, I believe I'll be able to share that information with those that would like to have it.
I believe if you would email that to me, I could post that to my webpage plus several others.
I can do that.
Send it to me too, and we'll do the same.
Okay, that I can do. I would love to share the Quose Act document. That I would definitely like to share with the public, and I will give that, because that is something that it takes time. I had a friend, believe it or not. I even have something too, and I'm going to share this also. I actually had the Attorney General out of New York actually share with me his complaint, his personal complaint. When somebody had seen my document, because I shared a document when I was filing my criminal complaint upon the court. When I filed my criminal complaint and they saw what I had done, because it was a very big folder. Well, anyway, I shared that with that person, and the person who I shared it with actually shared it with the Attorney General out of New York. And when he saw my document, he somehow got the document. I don't know how he did it, but anyway, he sent me his personal complaint. I will be glad to give that to whoever wants to take their case to court, because that is an exhibit. Any case law or any cases that have already been addressed in court under court of record is a public record. So I will share that with you. I also have another one. I have several I'm going to share with you that they can use as attachments, as evidence when they make their claim regarding the foreclosure, and also when they address their identity theft. Because this is
these
all.
Must be... Go ahead.
Go ahead. No, go ahead. These are documents that I actually used in my case, and I'm willing to share them now with those who are willing to address the court. So I'm willing now to give you some of my documents that I can share that I know that won't hurt me as jeopardizing my case. So I have documents that I am going to be sharing with you that you will be able to share with them. We will do this in in other words, instant message. We won't post these on anyone's wall. So in other words, they cannot share those on their wall, but I'm willing to share the documents with them so they can share those documents with other victims.
And
Does that make sense?
Yeah, it
The
does.
only reason
Hold on,
why I'm
Michelle.
asking.
Let Dave speak a minute. Go ahead, Dave.
Oh, go ahead, Dave.
What I was going to say, once you have all of your documents together, you want to make sure that you file them with the clerk of the court. And
That is
get
correct.
Get an extra copy made and send it to the grand jury foreman.
Yes.
Will be reading.
Okay.
Another thing I want to bring up about the grand jury. Okay, once the grand jury foreman receives this paperwork and understands the fraud upon the court, they can take further action. Only the grand jury can issue the warrant for the arrest of the wrongdoer.
That is correct.
So this will really aid the party filing against the court and the officials, and that will also aid the U.S. Marshals and the sheriffs.
That is correct, and that's a good point you brought up, and that's under the same, and that also falls under the same scenario as a criminal complaint. That's why in other words, let's say you filed your criminal complaint, because that's what you're going to do, and let's say that the sheriff's department or your police department takes your claim and they inform you now that they believe you have a criminal act.
Hang on a minute. We'll get to you in just a second, please.
It's the same scenario.
Michelle, hold on a minute. Michelle, there was one other gentleman that wanted to speak up. Let him speak first.
Sure.
So the floor is open. Speak up.
Oh, you know, I want to ask you, Michelle, this is Eugene, I just wanted to ask you something. Wouldn't it be just as good to get a legal aid instead of a lawyer and cheaper to do that work for you?
Absolutely. That's a good point, and I was going to touch on that. You are correct. The only thing is now, when you get, when you,
one at a time.
You can also go to a college, can't you, and see if the campus will help you too do that. And that would be almost free to the project.
That's a good point, Eugene. You can also, believe it or not, the law library also has a website, and that's a good point, Eugene. The law library also has a website that you can look up. Believe it or not, they will actually take your case for free, because these are new lawyers that are learning how to address cases. Because identity theft is not really all that hard of a case when you put your evidence together. And before you take your case to somebody, I ask that you put your case in order from A to Z as your exhibits in a folder or binder before you go to see a paralegal or somebody to help you. Because when you put your case together, your documents in order, it makes it so much easier for them to see the fraud, because there's many things you're not going to see with the naked eye. When you put your case together from A to Z, that's where you're going to take notice how they were addressing ex partes, which is what I had noticed when I did that. I didn't notice it right away. And when I started to put my case in order by date, I was amazed. So that's very important that you do that, and it does make it much easier on you, and it makes it much easier on them, and believe it or not, it will save you money. Because that's a good point, Eugene, what you brought up.
Not only that, it's the idea that they didn't pass the bar yet, so they haven't dirtied their hands yet.
That is correct.
Good point.
I'd like to say something to this. I'd
Sure.
like to interject something here about
Go ahead.
this. I know for a fact, years ago I took a case to Hastings Law School in San Francisco, and they were very nice. And what they, like these law schools and these students, what they look for is cases that could set a precedent. And they love the kind of cases that can set a precedent. So if you go into them and know that your case could be a potential precedent-setting case, your chances of them taking it on are very good. And if you have, say, for instance, a disability, okay, there is like disability law firms that will also help you with your case, like DRED.
That is correct.
Like that, Disability Rights Education and Defense Fund.
And that's why
you've got to have a good case. Yeah.
That is correct. Well, that's why I'm asking the people that are on the call, before you take that step, to do your homework, because just like the young lady that just spoke up, if somebody is willing to take your case as a lawyer or an attorney, they're not all bad. The problem is you have to know protocol. You have to understand and watch your attorney very closely, so that way you can object if you see that your attorney's slacking there and he's not doing you right under the law. You can then you can speak up and you can say, I object. That's not true. Put your attorney on the spot and say, what are you doing?
Oh.
So it doesn't necessarily mean that someone can't represent you.
Oh.
Yeah, but Michelle,
one at a time. Go ahead.
Go ahead.
Once you put them on the spot, okay, when they become the court and you're your attorney, they become you.
That's
it's hard
right.
for you to get them off that then. So it's better to get rid of them before they argue your case. Keep them all the way up until they get their case, and then you handle your own case. Because once they get there, they cannot go against the bar.
That's
They're
right.
there to protect them.
And
so
that's right. And
hang on, Michelle. Let them finish, please.
That's why it's better to have a legal aid do it for you, because don't forget, a lot of these lawyers have legal aids do this stuff for them, and it saves a lot of money. And that helps you a real lot, too, and you get to learn your case by talking with this legal aid, because they'll talk to you better than a lawyer will let you out with some of the things that are going on, because they're just as good as a lawyer mostly. They just don't argue the case.
That's a good point, and I'm agreeing with you, and that's why when I brought up about taking your case in front of a lawyer, that's exactly right. You put the lawyer on the spot right at the very beginning, and so basically when you do that, that's exactly what's happening is he's letting his paralegal help you, and you pay the paralegal. And when that happens, what you do is you go into their courtroom, not courtroom, into their office, and you sit down with the paralegal. And not only is she going to help you draft your paperwork, but she's going to make darn sure you understand exactly what you're doing. Because remember, they don't want a bad reputation. So they're going to make sure you know exactly what you're doing before you go to court. So you are correct. I agree with you.
You know what it is, too, Michelle, is you can't have the lawyer do it because he can't go against the judge and against the system because he'll lose his license.
That's
you
right.
You have to get rid of him first. You got to get rid of him first. You cannot take a chance of him talking for you at all.
Well, I'm agreeing, but when I meant taking their case to a lawyer, these are people that don't even have a lawyer yet. Now, if they have a lawyer and they find out that their lawyer is acting unfaithful, well, they have a right to dismiss that lawyer due to attorney misconduct. So there are actions that they can take to protect them. That's why they have to you have to educate yourself. So that way, when that happens, you can revoke that attorney from being your attorney and file a claim as under attorney misconduct.
But you missed the one valid part. Go ahead, Gene.
You know, another question I was going to ask you about that, Michelle, is why not when you walk in the door to a lawyer's office, you ask him if he's going to get you the real record or not. And if he can't get you the tape, don't go in there. Go and go to law school and get a legal aid to do your case for you. And you'll learn a lot more from that legal aid, because while he's learning and knowing the things, he's not privy as cheating yet. See what I mean? He's not a lawyer yet. He doesn't know what he has to obey and what rules he don't. He's following the law. So you'll be following the law with him, and you'll be learning what to do in court yourself.
Correct. And we're on the same page, Eugene. That's what I meant. That's exactly right. You're 100% correct.
Michelle, hang on, Michelle. A major point that nobody's hit on. Remember, save your envelopes. All your paperwork.
Oh, good point.
Come on with the stamp on it, because now you can get them in mail fraud.
Oh, that's a good point. Thank you for bringing that up. Make sure every document you do, you do certified. You get it notarized. You certify it.
You do it with a green card, because you want the green card, because that's the same thing as immigration.
That is correct.
You're going into a foreign country jurisdiction.
Good point. Thank you for reminding us on that. That is very crucial, and I'm glad you brought that up. You're right.
Okay, Eugene, go ahead. You were saying something else there. Finish up.
I was going to tell you that's correct. We did that. Mail stamp counts for mail fraud. We had them for mail fraud, too, and a lot of other things. But, I mean, it's so bad it's unreal. But the other point, too, that I was trying to make up with you is the lawyers. Once the lawyers, everybody's got to realize that if they can find fraud, and if they get, I know it hates the word tape, but see how many long things you had there. If any of that stuff has been changed in any of those days, any little part, that's fraud, and that vitiates everything, like you were saying, too. That's brought upon the court, and there's no statute of limitations on that. It's gone. Case over. You win. The minute you find any fraud in there.
Yeah,
am I right, Michelle?
You are correct. To our listeners who are listening to the gentleman who just made that statement, what he means is if you had gone to court and anything that was recorded, you want to ask for the master recording or any and also the transcripts as to when you were in court.
Excuse me, Michelle. Always take a camera and tape recorder into court. You don't have to ask permission to go into court with a camera or audio device. They try to say you do, but you have the right because it's your court, and the Supreme Court says you don't need to ask permission from the judge. You just take your equipment in and audio or videotape.
I'm going to respond. I'm going to respond that. I want to respond on that. Now, he is correct what he just indicated, but I'm going to tell you that a lot of judges are going to object to it. So what you have to say to the judge is, Your Honor, this is only for my purpose and also for a training. It's the same scenario, like when you get those phone calls and they tell you that
you missed one valid point there. Okay, all you have to do is tell the judge that's placating there is that it's for your education because you can't retain all the information, you need to have a record.
That's correct, and that's where I was going. That's what the
Supreme Court said.
That is correct, and that's where I was going with that. And what I was going to say, it's the same request like when you listen to somebody that calls you on the phone and they indicate to you that they're recording the conversation. It's the same scenario, and that's what you're going to use, just like Ed was just saying to you, what your reasons are. And the judge then cannot use it against you and object. Because I'm going to tell you right now, the judge is not going to let you take that tape recorder in the room unless you make those claims.
Well, no.
I'd like to add something here.
Courts. Many times I've had people beside myself, but I've had a lot of friends of mine who have been kidnapped and held for ransom for videotaping the courtrooms. Okay? And, I got 3 precedent cases in the state of Oregon on it. So
I wouldn't be surprised, Ed. There was a lady in the background. She wanted to ask a question.
Go ahead.
Well, I wanted to make a statement towards that. I knew this years ago.
Hang on a minute, one at a time. Let Goldie go, and then you follow right behind Goldie.
Okay, I'll be quick. Years ago, when I was doing my case between 2008, 2010, I found a federal law. I don't remember the law number, but I'm sure this could be looked up pretty easy, that supersedes all audio tape recording laws in every state in the United States. And the law was that you are allowed to record in the commencement of a crime against you. So I put in my court document, it was in there, I put it in there that I record all crimes against me.
Mm-hmm.
So, and they could say nothing. They could say nothing. So,
well, and again,
hey, hang on, Michelle, hang on, because let her finish, and we got another one behind her.
I am, Ed.
Okay.
I'll have to try to search it again. It's been many years.
Well,
but there is a federal law that says you can tape record in the commencement of a crime against you.
Well,
and I consider it all a crime against me.
Well, again, the codes and the laws that you're referring to would. That's why people have to go to get their manual before they even address the court.
Okay.
Those codes and statutes will be in the Federal Civil Rules booklet, and that will fall under Title V, Disclosures and Discovery under Rule 26, Duty and Disclosure under General Provisions governing discovery. So if you get the Federal Rules, Civil Rules booklet, you saw how quick I came up with that. It's all there in your hands. It's all there. So if you, that's your number one priority before you even go anywhere. You're going to get that manual, and you're going to.
Excuse me, Michelle. We had another lady that wanted to speak up. Let her speak, and then we'll get the floor open. Let's people speak. So next speaker, speak up, please.
Michelle, I want to ask you. I want to try to get a copy of the document regarding that you take to the property assessor's office. Do you have an email that I can get a copy of that document?
Are you on my Facebook friend? Because I don't want her giving that out on the phone. Okay. I will make sure you get her email with her permission. Yes. And as soon as you send me a message, we'll work on getting you that information.
Yeah, I've sent you several emails on the 14th on Saturday, Mr. Johnson. We've already talked. And the document
hang on a second. Let me step in, intervene on her question. You can, if you go to your county, like I live in Lake County, you're going to go to your county under the property appraisals website. When you go to your county's property appraiser's website, you'll be able to get that form. All those forms are on that website. If you don't see it, you can personally call them and ask them for that form or forms, and they will give them to you. There's many, many forms to your advantage. So you actually can go to pardon?
Yes, ma'am. That's what I did. I did those two things, and they didn't have a form. So I was going to create a form for myself, but I want to see examples.
What form was it that you were looking for?
The one that you're saying when you say I do not consent to the taking of the property, you need to record within so many days.
Okay, that is what's called ownership of property. So the name of the form is called ownership of property or ownership of the deed.
And that's what I did. I mean, I wrote that down because I went back and listened to the calls. I couldn't get all the case law that you cited from last week, but I wrote that down, called them, went on the website, and they didn't know what I was talking about. You couldn't find it? They didn't. Right. No, ma'am. They didn't have anything.
Okay, what I will do is I will share. Some of these. Yeah, I had a feeling that was going to happen. So I'm going to be sharing. I'm going to be giving you some of those links in instant message or by email.
Okay, I'm going to need email it on Facebook. And Michelle, one thing I'm going to ask you to do for everybody that's on the line and that's not on the line. Before I make this comment, I'd like to ask you this. Did you, from understanding, are you telling me you went to your state attorney general, you brought a criminal complaint, but that state attorney general is going to federal court under a civil action? Is that what you're saying?
what I had done is I went to the police department. I had filed a criminal complaint under identity theft. I also had informed the judge as to my criminal complaint at the time, because that's when I had received the summons and I knew it was fraudulent. So what I had done is I went and I filed a criminal complaint under identity theft, and I gave a copy. Now, in other words, I didn't petition the court. I was only giving the judge a copy, and I was informing the judge at that time that he was addressing a fraudulent claim that was brought forth upon the court by the plaintiff when I had received my summons. After that, what the plaintiffs were doing was bringing me into court on my criminal complaint. So in other words, it was a conflict of interest. As you know, when you file a criminal complaint, they cannot bring that claim upon the court. The only party that can bring a criminal complaint upon the court is the state attorney's office or the attorney general or the U.S. Marshal. So what they did is they were addressing themselves as the plaintiff, and they were bringing me into court on the notice to the judge regarding my criminal complaint. So that was a conflict of interest, and they also violated my due process rights by doing that, and they violated the due process under the Criminal Act. So in other words, they were tampering with a witness, and I was the witness. So when the judge caught on what was going on, they were not allowing me to bring my evidence upon the court. So they were committing fraud upon the court. I had turned to the Attorney General's office, informing them about my criminal complaint because it was in the process. So when I turned to the Attorney General to ask them for help, what they were doing at first was claiming they couldn't help me because they don't help those that are the victims. In other words, they only help those that committed the crime. And what I had learned, and the reason why that was, is because when I was calling them, I was telling them about a lawsuit. As soon as I mentioned the word lawsuit, they were denying me help. So then I woke up to reality, and when I called back the Attorney General's office, I didn't say anything about a lawsuit. What I said was I'm a victim to identity theft, and I have a serious problem. When I addressed it that way, the Attorney General looked, and when they noted that I was telling the truth, that's when they got involved, and it went from there.
Okay, but what I'm asking, Michelle, is the Attorney General filed a criminal complaint in federal court?
Yes, we have gone. We're going federal with my case. In fact, I've already signed paperwork on it, and it's been forwarded now to another special agent who's the IRS.
Okay, so we'll be criminal, not civil, correct?
That is correct. Right now. My case went from civil to criminal.
Okay, let me ask you to do this if you think about it with your case.
Mm-hmm.
Because I'm in a state where, unfortunately, I cannot show you the case laws back here, what's going on in the non-judicial state, where people are losing their homes without any court action. It's just simply a tenant and you lose your home. Nobody's proven anything in non-judicial states. If your case is criminal, can you see to it that they either amend or do something to add?
I am.
All others similarly situated.
I am. I'm not just speaking on my behalf. I'm speaking on all 50 states. That is exactly what I'm doing.
Good. And let me say something about the legal aids program here. They have such a legalized criminal syndicate here that if someone goes to the legal aid to get help or go to to get a law school to help them, they must go to the legal aid program, the federally funded legal aid program. If they do not assist you, the legal aid say, no, I will not help you, the law schools are prohibited from coming in and helping someone. All
that's a good point.
State,
That
state and federal dollars.
You are absolutely correct on that. Let me
one at a time.
You are. That was. Thank you for bringing that up. That she has got a good point there. Now she's talking about low income people with low income. Also, that will fall under the same category which she just brought to light. Because I was a low income person, as soon as you mentioned the word fraud, that's exactly right. They came back and said they would not help me.
And let me add this, Michelle, about the legal aid program. I have a case law back here that one day I hope you can read. This man owned his home for like 27 and a half years. He went to the legal aid programs. And these programs are federally funded. They're part of the Legal Services Corporation Act. The person who was part of that legal aid program pretending to be his lawyer sold him out. He ended up working for HUD, did not tell him about the grievance process. The man lost his home. So that's how foul this is. He went to federal court, and the federal judge dismissed the whole case. So these federal judges are with the legal aid programs, are with the bankers, the mortgage companies. So Godspeed. I hope you are successful in your case, and I do hope this will be a precedent-setting case to help other people. And with that, I yield.
We will, sweetie. That's why the gentleman that you're referring to, that's why he has to learn how to file what's called a notice to vacate. Anybody who has lost their homes, just as to what you claimed, anybody who lost their home, and even them losing their home and it's been sold, it's not over. I want you to realize this. What this young lady just brought forth is true. That is exactly what's happening. That doesn't mean you've lost. You feel you've lost because they want you to think that. There are other ways around it. So I want you to realize you might have lost your home, but you haven't really truly lost. You have to educate yourself. You have to get documents. You have to call your bank, get payment histories on your checks, look and see who endorsed your checks. These are things you have to do if you fall in that category. There are many things you have to do.
Your check. Michelle?
Yeah.
All government agencies are funded by the Fair Debt Reduction Act. Therefore, all of these judges, lawyers, and attorneys who are blocking your information from getting into court are committing fraud against you. Period.
That is correct. That's correct. And and you have to understand why they're doing that. The reason why they're doing that is because they know, just like you know, you have a identity theft claim. Not only do you have identity theft claim, but you have a tax claim, meaning that they're not supposed to be sharing your debt. The bank is not supposed to be sharing your tax information nor your Social Security number. But that is exactly what they have done. That's why you heard on the news just recently with Wells Fargo Bank. What did Wells Fargo Bank? They were using your Social Security number, and they were going into your own bank accounts, stealing money out of your bank accounts. Many of you probably aren't even aware of it, because what they do is they don't take big lump sums of dollar bills out of your checking account or your savings account. They don't want it to be obvious. But what they're doing is they'll take out $25, they'll take out $50, and what they're doing is they're opening up a new account with your identity under secrecy. This is what the banks are doing. The people that work for the banks. That's what they did, and that's what speaking of that, that's where the bank regulators come into play. You also have to file a complaint, a criminal complaint with the bank regulators. These are things you have to learn and you have to do, which is what I've done and learned. So once you realize what you have to do, things will fall into place. These are little things that your lawyers and your attorneys, paralegals, judges, whoever addresses law, they don't want you to know this. I'm giving you information that they will not tell you. In other words, I'm giving you the bombshell that you need to learn in order to reopen your case. Okay? Any other questions?
Well, Michelle, wouldn't it be good to add an affidavit and make them sign an affidavit against you so that you have to go to court to make sure they got your documents?
Well, when you address your documents, it's in an affidavit form, and that's why you get that's why when you address your documents as to addressing the court or any law enforcement, I'll give you some examples so you have an idea. When you address your documents for the court, you're going to address yourself as a claimant, and you're going to address it in a form as an affidavit. What you do is you're going to take your affidavit form and you're going to get it notarized. After you get it notarized, then you're going to take that same document and you're going to take it to the clerk of the court. You're going to have the clerk of the court stamp it as entering it into evidence upon the court before you give that document to any judge or any legal official. You're going to do the same thing even with the police department. Now, here's what I did when I filed my criminal complaint. What I did is I sat down on my computer and I addressed an affidavit criminal complaint on affidavit of fact or facts. Remember, when you address an affidavit on facts, you do not lie, don't deceive, don't hold anything. In other words, don't withhold any evidence that will hurt you. If there's something you are aware of, you do not lie, because man, they will use it against you. So what you do is you're going to sit down on your computer and you're going to outline an affidavit regarding your criminal complaint as to identity theft.
Okay. Excuse me, Michelle. The one word I would like to say, I don't use the word claimant in my stuff at all. I use injured man or party because claimant is a court word. That way you're whining and the judge can throw that out faster because you're not claiming you're alive. You're claiming the straw man account claimant and you're dead.
Well, what you would do, that is, you got a good point there, Ed. I'm not disputing that. When I say addressing the claimant, I don't mean just address the word claimant in your name. I say claimant, and then I address myself as that's why I read to you at the very beginning of this call, if you remember, I'll go back and rephrase that statement. I said that I was, hang on, I'm going to go back and find that document so I can read it to those listeners again.
Then I want to ask you something, okay, Michelle?
Yeah, go ahead, Eugene.
That's why I address myself, and that's a good point, Ed. You brought up a good point. When you address yourself, you can also claim that you are the injured party. That is a good point, and I would recommend that you say that and do that. What I did is I said, I, Michelle M. Christensen, one of the people. You're referring yourself as a people. When you say you are a people, that means you are a live, living being. Or if you want to, you can use the word live, living being, injured party, as a claimant.
Michelle, can you do that when you come into court? Stop all the foolishness and just say that right away. I'm a live claimant myself.
Well, you have to put that in your. Well, that is you are correct when you go into court. Yes, but normally you don't have to do that because it's already in writing. When you address your document, and you are entering it in the court of record, it's already in writing. Now, what you can do is you can take.
Yeah, Michelle, let Eugene speak for a minute. Go ahead, Eugene.
Here's the deal, Michelle. If that gets lost, you'll have it on the tape. So it's good to say it.
Well, that's exactly right. That's what I was just getting ready to say, Eugene. And that's why I put things in writing, because what I do is I take that document in my hand.
Michelle, let Eugene finish, please. Go
Well,
ahead,
I'm answering to you.
I know.
Eugene's
Just hang
question.
on, Michelle. Let him finish, and then we'll get back on the answer. Go ahead, Eugene.
Oh, okay.
But here's another thing, Michelle. When you write the affidavit, it must be answered with an affidavit. So when you're saying tell the whole truth, the whole truth, one of you has to be lying and committing perjury. They will not answer you, and then you can get a summary judgment. And when they can't answer the summary judgment, and they've been estoppel.
That is correct.
So
and that's why Eugene.
Let him finish, Michelle, please. Go ahead, Eugene.
There's a lot of ways that if you learn the tricks of what they do, you can simplify a lot of stuff that you've been talking about and saying it, and using the key things out of there. If you show one fraud in certain areas, you still win the case, and you stay there and don't get caught in a maze of all this stuff. You stick to where you're at, what they got them personally for, and they're dead then. They can't do anything. See, that's the point. And the judge has got to be on notice then that he knows what's going on. And if you're pro se, he should be understanding the laws while these people are in the courtroom. And if they make a mistake, he's the referee there. He's supposed to help you. I did that in my case. And under federal law, and plus my case is a contract case on the First Amendment. See, that's what he screwed up on really big with me. So basically it says in there, he says to the attorneys for the city, I must help him as a pro se to see that everything gets a fair and square shake. So that means when you go there and play stupid, or you say, I can't hear, so I must have the tape, they can't stop you then. And plus, not only that judge is supposed to see that he helps you understand it. If you don't finish up on your questioning, he's got to make it seem the rest of the question answered by him. You know that, don't you? Michelle?
Never use the word pro se. Don't use the word pro se, Eugene. When you use the word pro se, when you use the pro se, you're putting yourself back into their jurisdiction.
Right.
You use the word claimant.
Now, you live man or woman.
Yes, that is correct.
Word that brings you back into their straw man account.
Right,
in the verbiage, that is correct, Ed, but in the verbiage, look, there's certain ways you have to address the court, like it or not. There are certain ways you have to address these documents pertaining to court. Otherwise, they're going to object to taking even your record. They will nitpick like you won't believe.
Mm-hmm.
You can correct those statements, or you can protect your butt by making certain statements after you say the word claimant. You can claim yourself as a live, living being. Otherwise, you're going to make yourself look like an idiot in court. Bottom line.
Well, here's what I was wondering about this now, Michelle. On the withdrawal slip that they got, this is for every court, they put the word pro se down there, that a pro se is now an active member of the court. And if that person commits fraud, it's fraud upon the court too. So they actually put that word down in that when you withdraw anything. So
that's right.
Where do you go from there? Where do you go from there with that word?
Well, Eugene, that is correct. And remember, they're using trickery. It only takes one word to get you back into their court. Now, you have to understand, Eugene, that's why I'm telling our audience who's listening on the call that they're not just going to file these documents and cut corners. If you think you're going to win your case by cutting corners and not learning protocol and not learning how to address forms properly and not learning what falls next under the Federal Civil Rules booklet, I'm telling you, you're going to be setting yourself up. Do not think that you can bypass and not learn the protocols regarding the Civil Rules booklet, because it's the same guidelines that they use, meaning your attorneys, your judges, your paralegals, etc.
You'd be surprised what they use. I mean, it doesn't always go that way. They change everything in there. Let's
they
be
do.
Real here. You got to.
And that's why you have. Well, Eugene, that's why I'm telling our listeners on the phone call, they have to do their homework. And if they're not sure if they can do it, then they need to find somebody like you, Eugene, who's done it. In other words, who knows those tricks. They need to turn to friends.
And mostly all of it is tricks. It's just like when Clinton said, what does the word is mean? Now, the lawyer questioning him could have said, what does it mean to you? You're on the stand. They wouldn't say that. See, the idea is, he says, what does the word is mean? Well, what does is mean to anybody? What does it mean to you? You're the one that's being prosecuted. That's what you got to say. And you got to make sure that they answer the question. And if a person is going to court himself, it's best to get a yes or no answer to everything. Did you know this was fraud? Yes or no? Because they're either going to admit to the deal or they're going to lie. And you're going to have
a good point. Very good point, Eugene.
Learning the law.
That's a good point. Let me step in a minute, and I'll let you finish, Eugene. Ed, will you stop it? Stop interrupting us.
Go ahead, Ed. Let her go. Go ahead. Go ahead, Michelle.
I wanted to bring a good point up while he was on that note. I am going to let them talk. Eugene, you brought up a good point, and what I was going to say was, actually, now I lost my train of thought. Go ahead and proceed, and I'll think what I wanted to say.
Yes or no? You were talking about the yes or no issue.
Yeah, but there was something I wanted to touch on while you were on that note, and I'll come back to it.
Yeah, because don't forget, even if they try to get out of it, they're answering yes or no to it. So either they're going to lie or they're not going to lie. So basically, you got them cut short right there. No matter how they explain it, it still is a yes or no answer before what they try to explain.
Yeah, now I remember, Eugene. Now I remember what I was going to say. What you brought up.
Okay.
When you're what Eugene is bringing to your attention is a very crucial point, especially when you're addressing jurisdiction. When you're talking to the judge, let's say you're in court and you've gotten where you can go into court and you feel comfortable. Always ask the judge. In other words, you're going to make the judge answer back by asking a question. Never answer to the judge by answering the judge. So what I'm trying to say is you always answer back with a question. As soon as you answer with an answer, you're giving that judge the opportunity to move forward against you. But when you answer with a question, you're not opening the door to give the judge an action to come back at you. So always ask with another question. Does that make sense to my listeners?
Yes, but could I ask you something to you? What you're saying right now is that guy sitting on the bench with the black robe is crooked too, right?
That's exactly what I'm indicating. So that's why you always ask them with a question, and what you're doing is you're blocking that judge from moving forward and, in other words, moving to dismiss your case. So when you ask the judge, by answering the judge, you ask. Go ahead.
What I was going to ask you is when you're telling these people to go in there, in the courtroom, nobody is your friend. Let them know that. They have to be prepared for everybody in that courtroom. The clerk, that's the one that makes a lot of decisions by mail. You've got to watch everything that's being done in that courtroom because you are alone. Believe me, you're alone.
That is correct. That's why Ed, not Ed, Eugene. That's why I can't say it loud enough. Please, people, you have to learn the civil rules procedure booklet. If you can get that down packed, and what you do is you take your document with you in court, the one that you are filing on, and you reference off of your notes. Always take your notes or whatever it is, your documents with you, and you reference off those notes. Don't let them push you around. You can take as long as you want to answer the judge. If it takes you an hour to answer the judge, there's nothing that judge can do. Don't let them force you into answering quickly or confusing you. Remember, this is your life on the line. So you can take your sweet time, and you want to answer the judge by making, in other words, by making a statement as a question. So you want to answer back with a question, if that makes sense. Go ahead, Eugene.
And always remember the affidavit, because an affidavit must be answered by an affidavit. And once they commit perjury, that's it. And they will not answer an affidavit that shows them doing fraud. So then you from the federal court, they came from state court. So they're the same people up there, even the ones sitting on the Supreme Court. You've got to make them do their job. You've got to hold them to their legal actions of the law. The way they come up with the law, that's the way you shove it back up to them. And that's the key. And you can't be afraid. What are you going to be afraid of?
That's right.
What's the problem?
To our listeners, as to what this gentleman is trying to bring to your attention, what he's trying to tell you is they're human just like we are. Don't be intimidated because they're sitting in there with a black robe on. Don't be timid. So, what he's trying to say to you, once you realize when you're in court and you can see that the judge is struggling, okay, what you want to do is move quick and say, you make a statement to the judge. I move for a dismissal. So, in other words, you have a right to say, well, Judge, I'm moving for a dismissal. Right, Eugene?
A directed verdict.
Yeah,
right, and
exactly.
Then you can challenge them and then sue them for bringing you in there.
That is correct. So that's what you...
You can slap them around anytime you want if you know what you're doing.
Right. So that's what Eugene is referring to, gentlemen, and that are listening on the call. He's telling you that once you realize that you have the upper hand, you right away get your stuff right. That's why it's important to know protocol, because the next thing you're going to do is you're going to move and you're going to say, well, I object. I move for a dismissal on the evidence that you're bringing forth upon the court. And believe me, that's how easy it is, as long as you do your homework.
When you go to court, Michelle, you can just go in there and ask them. Automatically, you're going to want your tape. You don't want a tape. You want a different judge or a different court reporter. That's just the basic thing. You got to stay there. The whole over freezes. You stay there. That is
a good point. Thank you for bringing that up, Eugene. That's a very good point. That is a very crucial and important thing to remember. And because you can even ask for a copy. You can actually ask for a copy of the in a CD form too, and it's I think $5.
Michelle, all you do is bring up the O.J. Simpson case, and that case, the lawyer right there, he had the black guy Cochran. Well, he asked for the tape, or had one of his people stay right by that court reporter and took that tape right out when she gave it to him. He knew, because he was an state's attorney, what they do. So that's why they were a little bit mad at him. He knew the tricks. He knew he could sit there while Marsha Clark and the other guy said stuff, because he knew they were going to change the stuff. They have to make it worse. The reason they changed that case and brought it to L.A. is they wanted to do it in front of a black jury, or there was more minorities in L.A. County instead of a rich one like Brentwood over there. So basically they had to doctor up, whether he's guilty or not. The minute they make one mistake, the case is out the door. The minute there's fraud, it's over. It vitiates everything.
You know what else, Eugene? You know what else, Eugene, we didn't touch on, and that's the patents. Remember, these contracts from the banks are also patent. They were, in other words, they were addressed fraudulently, and because of the wording in the contract, they're actually patents. They address these documents. And that's why it's crucial to understand where I'm coming from when I say identity theft. Because remember, these are all patent. They sold your note. The promissory note had no value, but the instrument had value. So what they did is they sold your note. They made money off that promissory note that had no value. But what they did is they sold the instrument, they transferred the instrument to the new lender. In the meantime, all they gave you was a piece of paper of no value. They can't sue you on that. And they can't split it. Remember that. They can't split the note from the instrument. They got you thinking that, Even attorneys will say, "Oh yeah, they can do that." No, they cannot. You have to understand these things.
Well, once you get the inside game and you know how it's played, you can see it. It's just like a guy that can play music without hearing a note, without seeing a note. You just know what they're exactly going to do. You look to the look of the eye. You look to what's going on. Most of the judges, when they're breaking the law, are looking down at the floor. They can't look in the eye, so you watch that. When they turn to the left, that means something. When they turn to the right. See, I was brought up in this game. I've seen this game being played. You can tell what moves are being made. And then when they try to overpower and bully you, once you stand back up to them, they sort of swivel down. They can't do it because they're battling the law and you.
That is correct, Eugene. That's a good point for our audience to realize that. Now, you have to understand, Eugene, I didn't have that experience like you did. And believe it or not, Eugene, what you just touched on is so true. And it's very easy to pick up on, even if you're not trained in that. I had that judge so nervous that's exactly right. I was touching on key elements. And remember, you petition the court. When you file your paperwork, you're going to petition the court, because when you petition the court, you don't pay court fees and costs. Remember, that's why the clerk of the court wants you to pay fees and costs. As soon as you make those fees and pay those fees as they're claiming, you're now in their jurisdiction.
Don't have to.
There's
Michelle?
many, yeah.
There's actually a ruling of the Supreme Court that says we do not have to pay filing fees and costs to the court because we own the court.
That's correct. That's correct.
And another thing I wanted to bring out, that some judges, state judges especially, says you cannot use state law and federal law in the same case. Well, then what people need to do is point out to the judge, you better check the state's environmental protection laws, because they use federal law in those laws.
That is correct. I want to emphasize on that. That's a good point. That you brought up a good point. I want to emphasize on something on that, because that's another good crucial part of what you need to know. What he means is, okay, you're going into state court. Now, what they are trying to tell you is you can't address federal law unless you find a federal law violation. Very good point. I'm glad you brought that up. That is what they're referring to. Yes, fraud upon the court is a federal law violation. There's also other elements to federal law violations, and that is identity theft. When you can prove identity theft, you remember you didn't consent to the taking. When you got your summons, you were ordered to appear in court, and you were ordered to answer to the plaintiff within, 21 days, I believe they say on the summons. So
10 days.
Yeah, 10 days. There you go. So there's my point. That is okay. So when you prove that you're a victim to identity theft, well, guess what? There's your federal law violations. You can also file what's called a notice of removal. These are things you're going to learn, and you'll learn these things when you read the Federal Rules of Civil Procedures booklet manual. Because the first thing you would do, first of all, the first thing you do is you file a notice to dismiss. After you file your notice to dismiss, then you file your next move would be a notice of removal, or you could file a notice to vacate. It all depends on your case, because every case is different in certain ways. Most cases are alike, but your case might not be. In other words, might be a very simple 1, 2, 3 case. My case happened to be a very big case. So everyone's case is somewhat different. You have to know these things. Your case could be a very simple case where it's over in 1, 2. I mean, I'm not joking. Your case, you probably could win your case in 2 settings. It's all knowing what to do.
Another thing is the First Amendment.
Another thing I want to point out, Michelle, is this. If the judge says the federal law does not apply in the court, you ask the judge, well, how do you receive your paycheck?
That's right.
Do you receive a Federal Reserve note as payment?
Mm-hmm.
That's right. That's another.
Well, that's federal law.
That's right. And Dave, that's a good point. Now, how do you ask for that? You put them on notice to show cause. Remember, you're the defendant. You don't have to show cause. You're going to object. Now, your plaintiff will order you to show cause, and you're going to object to that. But you can surely make them show cause, because remember, they're the ones that brought the lawsuit upon you. So what you do is you ask them to show you that cause, and that's a good point.
Michelle,
and you make that judge answer to you. Explain to me, Judge, why I can't address a federal law violation.
Mm-hmm.
Make them answer.
I was going to ask you too about the First Amendment. The First Amendment. If you got the First Amendment, you got them all.
Right.
Because if you look at the First Amendment, it takes into consideration all the other amendments. Don't ever
and remember now, regarding the state court,
we're not lawyers. We're not lawyers. We're just giving advice to friends. But the First Amendment is always the key.
Right.
It holds the key to the rest of the amendments. Once you got that one, you got everything.
And here's another good pointer to our listeners, because we're all learning. Here's another good thing too. Remember, because you're in the state court, you can ask any legislator, meaning your own state senator or governor, to review your case. Did you know that?
Well, yeah, and you can also ask all the judges in the court to review your case. It's like a block or something like they call it like that. But you can have every single judge look at that case. Sure,
you can take it all the way up to you can request on a notice of removal. You could take it to the Supreme Court. Heck, you can even have the president review your case. This is what they don't want you to know.
Did you know why I told you about the First Amendment, to use the First Amendment? Because the Supreme Court must hear a First Amendment case. That's what a lot of people don't know. They must hear it. Did you know that, Michelle?
Yeah, that's a good point. That's a good point.
You're all the way ready to go to the Supreme Court, and when you put them up against it, no matter who they are, how smart they are, Loretta Lynch, anybody there is, they must lie because you caught them lying. Because once you get into court and you start winning, then you know there's lies behind the scenes, and at the end, you're going to be the winner. That's the way it works. But the people, a lot of times, don't stick together and do it the way they should do it. And if they do it the right way and they march for the right things, you got it. You got your court back. You got your land back. You haven't got it now.
Well, here's a very good point. Here's something else that you've got to be aware of, because a lot of people, I'm sure we have their heads spinning right now. But now remember, the mortgage copyright derivatives. Remember, that's where the patents come into play. So, if you, pardon?
Patent law, right?
Yes. As to the copyright. Well, guess what? Not only did they violate your rights on that, but guess what they did also? Remember, now this has to do with your taxes, your Social Security number. They did the same thing, because what did they do? They took your personal, private information, and they used it pertaining to their documents, that patent. Well, the banks committed coercion. They stole. Not only did they steal from you, but now they're stealing from the legislators, Congress, the president.
Well, we got to go back to Michelle, where Goldie made the point on that she's going to look into the case where they said that she can have being taped. Goldie, if you tell more on that one, it ought to be really good, because once you can have that illegally in it, they can't use the thing in court saying that, well, that's not usable because that was not supposed to be done that way. See, now,
right, and that's why that's a good point, and that's why when you're in court and you're confronting the judge, you use the word, do you comprehend? And I was just.
Go ask Goldie about that case there, because that's very important to the people, because if they realize that they can get their tapes right there, right then and there, they could be taped, then that wins their case for them.
Well, I got some good news to tell you, Eugene. Because I know you were very concerned about my circumstances. I have to tell you, they're very nervous. And the young lady that was on the phone earlier with her question as to what I'm planning on doing, well, like I had spoken last week on the phone, I'm going to be addressing the dollar bill as the note. I'm going to be addressing the instrument with the gentleman. I also have some documents that I'm going to be bringing forth. Keep in mind, I'm going to have that person and those in that room that day, they're going to be initialing my documents. I'm not just going to hand over my document. They have to put their initials on my documents that they had received them. I'm not just going to hand them over freely.
Oh, of course
so,
not.
and I'm going to make sure that they comprehend exactly what I'm saying. And you have to, and Eugene, you have to understand, realize that what I'm going to be asking for in a memorandum, I'm going to put them on notice that I want a memorandum addressed right now in there, and I'm going to say there will be no more foreclosures addressed, period. They're all fraudulent.
Put it under mandamus, too,
Yes, that is another legal term. Yes, correct.
So when you do that, don't remember, we're not lawyers. We're just friends talking like you'd be in a bar.
That's right. We're just, that is correct. And I'm sharing with you my knowledge. I'm sharing with you my knowledge, and I'm so proud that I'm hoping and praying that I'm not just doing this for me. I'm doing it for all of us that have lost our homes or in the midst of losing their homes. I'm doing it for all of us.
Remember the First Amendment.
Another good thing, too, that I would ask that you request for those that are going to address the court, that all notaries have to have a photo ID along with their ID number. That will also put a halt to all these notaries notarizing documents fraudulently. Another good pointer that I need to bring to your attention, when you're looking at your documents, those that have gone to court, look on the notary's statement. If there is no ID number on the notary's statement, it's fraudulent. Also, make sure that there's a state seal on your court documents. If there's no court document stamped on those documents, you can claim that they are fraudulent, meaning you don't know if that judge actually signed the document or not, or the paralegal. Because if there's no court seal on those documents, they can be classified as fabricated documents. You don't know for sure if that was really signed by the judge or the clerk of the court. Those are things you need to know, and you can address that as part of your claim.
Did you know why the lawyers usually put Esquire after their name? Ed will tell you. I know that. He knows they're landowners, right, Ed?
Mm-hmm.
They're landowners. He's their landowner.
Well, go ahead and elaborate on that. Go ahead. I'm gonna let you have the floor.
Ed could be real good. Ed could be good at this because we'll get him into this. We're gonna go.
Well, yeah. Go ahead, Ed.
So it is.
I know why, but I want to give the floor to somebody else.
Yeah, Ed can handle it with Esquire, the landowner. Go ahead, Ed.
Well, yeah, that goes all the way back when you go technically to the 15th century.
Right.
And that's when they were claiming land that wasn't theirs. And so by using the Esquire, it is landowner. And be careful with anybody who uses that behind their name, because they will even go after you for their own gain.
That's right.
That is very true.
I don't trust any of them.
That's a good point, Ed. Well, that's why I didn't do that by my name personally, but that's a good point, Ed. And I'm glad you brought that up.
I never used that because you could get actually in legal trouble, because Esquire is an England terminology, not of the United States.
That is
Right,
true.
And that is where they end up, screwing up. So with the lawsuits that are going on, because I'm getting ready to file mine here pretty soon, with all my structure with Social Security conspiring with the local government that they could prove. Okay, this is when you do. That's the one thing. When you do your paperwork too, never sign anything. You autograph. Signatures are dead man's hand or woman's hand. An autograph has value.
Yes, I'm glad you brought that up because that was one of the things I was gonna touch on. Thank you for bringing that up. What Ed is saying, what you're going to, if you have a document and it says signature on it, you're going to take a pen and draw a line through it, and you're going to write ID autograph, and then you're going to put your name on it. And if you really want to be great, take a red ink thumbprint of your right hand, and you're going to put it by your name on the document.
Mm-hmm. And always use red ink.
Yeah, red ink is your bloodline. You can also do that when you have your papers notarized by the notary before you go to the clerk of the court. You also want to do that when you address your deed of trust as you being ownership. That's another thing. The lady was saying that she couldn't find the documents through the property appraiser's office. You might want to try the deed of trust website and see if that document is in there as under ownership. When you address your document, you can also do the same thing. Cross off the name signature, write autograph, ID autograph, and then do your thumbprint on that document and give it and take it to. Because what you're going to do is you're going to enter that into the court. You're also going to enter a copy of that to the property appraiser's office, and that is to stop. That is to stop well, it's like a notice to vacate. Actually, what you're going to do is you're stopping the judge from stealing your house under a writ of possession. So if you have gone to court and you have not yet gone to court for them as to stealing your house, that is your number one priority. Get that document as claim ownership. You're going to write in the document on that form that you did not consent to the taking. You're dealing with fraud upon the court. You did not consent for them to take your home, under fraud. In other words, you're going to write on it, it's fraud, and you're going to put on there identity theft. In other words, it's all about common sense. Use your own words, address the document, and get it in there. As soon as you get it in there, that stops the short sale, because that's what they want to do. They want to get you in there, then they're going to address the short sale. That's why, in other words, you're going to trump the short sale, because that's why they put it in the newspaper. They claim they put it in the newspaper. That's another thing. They claimed that they claimed with my case that they had put it in the newspaper. I got news for you. They did not. And here's another thing. You want to know what document only had the seal? It wasn't a court order now. It was from the clerk of the court as claiming that the bank had ownership of my property. That's it. You want to know what they bought my house for? $100. Now that was done by the clerk of the court.
Well, that's the boss of the court.
That's right.
The clerk is the boss.
That's right.
Here.
That's why I was. That's under the
check.
Yeah, and which falls under the QV, the QV Act, 1666.
Another thing too is when you're signing checks and stuff like that. If you're forced into doing it, always write under duress, because that way you can get it back.
That's a good point. Thank you for bringing that up for the audience. You are correct on that one too. And that's another thing. Good point. Here's another thing that you probably don't know. I mean, we're all here to help each other. Did you know when you receive a bill, that is not a true bill? Like when you're paying your electric bill, for instance, just goof around sometimes. Send it back to them and say, I'm sorry, this isn't a bill. I need a copy of the true bill. What you sent me was only a statement.
That's right.
So that's another thing. You'd be surprised with those with student loans. Oh, yeah, that's another one.
Well,
do that one.
Like
send them back the bill and say, I'm sorry, but I can't pay this. This is just a statement.
How about all the new electric companies that come out and ask the people to join new things? It's cheaper here, cheaper there. And they all come under the same heading, don't they? Because I asked one of the homes one time, I says, what kind of electric do you use? Well, we use the same thing. We don't change. Because all those one out there are usually phonies, and, you know, they run off the same thing, the same price, and sometimes it ends up costing you more.
That is true. It's another good point, Eugene. Is there anybody else that has a question, or are they just they must be content, happy what they're hearing? But yeah, Eugene, that's a good point.
Yeah, well, there's a lot of tricks that you'll learn along the way, even when you're a little kid. You know what I mean?
Mm-hmm.
You just see it. You know, that's why when we wrote that thing up, we wanted to put fraud that they committed on themselves, not that we're alleging, because they put in our case like that we allege this, allege that. That's baloney. We put all the evidence right down there, but at that day and age, they thought they could get away with it, but they can't. But the point about it is in a book, we put fraud by them upon themselves. That's when you brought up extrinsic and intrinsic fraud.
That's correct.
One is court frauding the court, and that they can't have. That must be heard.
That is right.
You're fraud, but if they're fraud, look out. See what I mean?
Michelle?
Yes, go ahead.
I'm putting qualified endorsements on the back of my check. Payable in lawful money. I think it's 28 stat 337 48. Let's see, it's doggone, I can't remember. Ed, do you remember what I put on the back of that check?
I have an idea. I have an idea what you're trying to say, and I can't cite the statute right off the top of my head either right now. But I do know where you're coming from, and that is that's a good point. What I would recommend
is you're quoting the law and statute to them,
right?
Mm-hmm.
And the only way they can actually pay that bill is through lawful money under that code. In other words, they got to take that check to the Treasury and have it paid.
That's a good point. Now, you just touched on something that's very, very good for the audience to hear. That is where I'm coming from, guys. When I talk about the banks committing identity theft, good point, awesome. Because remember, what did they do? They filed a lien. Remember, how would they know to file a lien? Meaning that the banks shared your personal ID with other lenders illegally. They can't do that.
That's punishable by 5 years in jail.
Oh, absolutely. Absolutely. And remember, you were deceived. See, that's why it's very important that you learn the Federal Rules Civil booklet, because those codes and statutes are in that literature. It's not a small document, guys. And you can get it for free if you look under the 2015 edition. Normally, for that manual, you have to pay around $100 to $200, even $300, depending on that manual. And that manual actually teaches you how to address your documents for upon the court. It also teaches you, like what Eugene is bringing to your attention. In other words, things you have to learn, like how to address a notice to show cause, how to object to when they make you answer on an order from a judge that you're not supposed to be answering to. I'm bringing these things up to your attention because they happened to me. And I was one of the lucky ones. I knew to object. You have to understand why they want you to answer to them. The reason why they want you to answer to them is because their next move is to move for a motion to dismiss.
Right.
And they're going to claim that you didn't have enough evidence to bring forth your claim. That's why they want you to answer real quickly from them. Yep, go ahead.
just letting you know this is at the bottom of the hour. Thank you. And I
Okay.
yield.
So
Yeah, go
well,
ahead.
I'm gonna yield. I want to give the floor to whoever has a question or answer.
This is Geraldine. I have a question.
You see, you've done very well today. And actually, when you go back and forth with one another, you start to learn more and more.
You know, there was a lady that was trying to speak. Try to speak up, ma'am, and your phone.
Yes, and you were talking about a manual, and the one that I understood was like 13 pages. That was the Federal Civil Rules booklet. Is that the one you're talking about, or is this a different one?
No, that's the one I'm talking about. It's called the Federal Civil Rules booklet, and it's going to be about 100 to 200 pages long. It's an actual manual. When you heard me say 13 pages, that is a document that I had put together. That 13-page document that you're referencing to has to do with just laws and codes that has to do with your rights, and that had to do with the banking and banking regulations. That's the 13-page document that you are referencing off of. So the manual is over 100 pages long, and the 13-page has to do with the banks and the bank's regulations, which also explains in there your natural rights under the law.
That's part of the manual?
No, it is not. It's a separate document altogether, but it's a document that I'm going to be sharing. It's a separate document.
So
you get that. I cited that document under the code. That's under Title 12. That's under Title 12. What is it? CFR 16. Chapter 2, it's under that. That would be under the
CSR 12.
It's Title 12. Yes, Title 12, United States Code, Title 12. The one you're referring to on the 13 manual, it would be USC Title 12, Section 95A. That will be the 13-page documentary. If you Google that in your Google search bar, you should be able to pull up that 13-page document. Now, that has to do with banks and banking, and Section 16 has to do with the corporation.
Okay.
Under Title 12.
And so this other one, Federal Civil Rules booklet. Now, that's
it's a manual. Yeah, it's a manual, and what it will do is teach you how to address your court documents. It's the same document, the same manual that teaches you how to address the court, and it's the same manual that the paralegals and the clerk of the court and the courts use. They use the same manual.
Federal Civil
Rules booklet. If you Google that in your Google search bar, a website will come up, and you want to go to where it says 2012 edition, meaning
I thought you said 2015.
Or excuse me, 2015. You're correct. Excuse me. Yeah,
okay,
it'll say edition 2015.
Don't confuse me any more than I already am.
I'm sorry. Yeah, 2015, and stands for the year of 2015. That's the only one that I know of. There is a 2012 edition, but you want to get the update. So the updated one is now 2015, and you can get it for free. Like I said, now a website.
Print that out. Is that
yes,
what you're saying?
You'll download it. You'll download it onto your computer, and save it on your computer, and you can print it out. Absolutely, it's the edition 2015. That one is for free.
Okay, I'll try to figure out. I didn't grow up with computers, so I'm.
All right. I'll give you a little summary. When you type in the Google in your search bar, a website's going to come up with different links to that subject that you just typed in Google. You're gonna scroll down, and you're going to look for the one that says Edition 2015. You click on it. That will come up. That document will come up, and you'll see what it says under the Civil Rules booklet, and then you're going to download it, and you're going to save it. And then, of course, after you save it, save as, then you're going to save it, and then you can print it out.
So what do I want to save it as?
You just click on Save As, and then it will download onto your computer, and then you click Save. You want to save it onto your computer, and then you click Save. And, of course, when you save it, that means that you can name it, and you can use it for other use later on your computer, and you can print it out, things like that.
Okay.
Thank
you very much. I yield.
What I do, ma'am, on saving documents is I put the date on them that I save them. And then I name them briefly, like federal law, so-and-so. However,
yeah, when you click on Save As, the link will come up, and like the gentleman just said, you can rename the document. And that's a good point. You would put the year 2016, and of course what the document means. So you can save it on your computer as what the title is, or whatever you prefer it to be. What'd you say, bank fraud?
Yeah, bank fraud.
Yeah, that's true.
If it all deals with bank fraud, you just put in the like today's date, 10/17, space bank fraud.
Well, you can put bank fraud, but you want to put Silver Rules booklet, so that way you know it's your manual.
Well, yeah, but I'm just saying that.
But that's exactly.
Yeah.
Good point.
Oh, and I think I do know how to endorse your check on the back. Your qualified endorsement. It's 12 USC 411. 48 stat 337 is in round brackets. So you put a round bracket, 48 stat 337 round bracket.
That's a good point. You know, Ed also brought up a good point too, regarding your Social Security. He brought up a good statement that we could even probably add that code and regulation to what you're talking about. That's actually a good point.
Ed, could I ask you a question too? I was going to ask you about, he's telling her to get the 15, the year 15. I noticed when I looked into some of the stuff, and I got a pretty darn good memory, is that when I got something ahead of time, a document, that they'll somehow try to change it in the later years if they want to get it done, even though it's not changeable. Like I had one thing where it was written in letter E, and they tried to put it into a D to hide it because I caught them with the E. Then I found that I had the only person that had that, and it's never been changed. It's just been changed by the court. It's not supposed to be changed. It's changed by something up there. So sometimes when you get both documents, like the year 12 and the year 15, you might think that they tried to change what they really didn't change according to the law. They did it just to hurt your case. See,
that's a good point, Eugene.
There's another thing, too, with the FBI did that. See, when we were taking them on, we knew everybody was, not really, right. Well, how to say it nicely. But the point is we give them a transcript and say, don't lose this because it's the last one we got. Then when you get the transcript back, you see some of the pages really blurry that you couldn't read the words, so they'd put some stuff on it. Then all you'd have to do is get the other transcript that you had that you didn't tell them you had and look at what they're really trying to hide. And that eliminates everything into the cases. If you know how to trick them and use their tricks on them, then you're able to get everything from them that you need. So basically,
okay, well, Eugene, explain to the audience what you're trying to say. I know what you mean. So that's a good point. So basically, when you go to look for the edition 2015 and you're downloading it on your computer, I would recommend then that you also download the other one, which says the same thing, but it's for the year 2012. And compare the two documents as to the manual that I'm referring to, and see if there are any things that they changed that would hurt, that like what Eugene is talking about, because that is a good point. Because remember, this is an updated version of the other document that was addressed in 2012, and that is a good point. They because they are aware that we're catching on to the fraud, they might change some of the verbiage where we think it's in our favor, but in reality, it's not, or it's not.
It's a cover.
Right, exactly. Like it's just like you're in limbo.
It's just like when you're with the FBI. We had the transcript to them, and they would forward certain pages. Then you'd know when you put the copy that you had next to it what's worrying them. Then you can start digging deeper and deeper into everything. I mean, it's like being Charlie Chan.
Well, that's why Eugene. That's why I was telling the audience who's listening to put their documents in order by date in a folder, because that's why I'm asking them to do that, because just like you're pointing out, when you get documents back from the correspondence back from your request, as like from the when you're addressing the court or the banks for information, you can compare them with your document, because that is a very good point what you're bringing up. So in other words, what he's trying to tell you is check your documents to see if they altered them and see if the wording has been changed with your documents that you have presented. It's a very good point.
Or even with the manuals, they might change something in the manual that they want to favor themselves in the year 15 that's really the same law from 12, but they're not using that. So when you get the new one, you think you're getting a better one, but you're getting screwed.
Well, that's why I'm asking that's right, and that's why I'm asking those that are on the call to do their homework. But when I say homework, I mean go to your bank, ask for copies of your checks, and see who's endorsing your checks. Because you're going to be surprised. You might think it's John Doe who you wrote the check to, but John Doe is not the one who's endorsing your check. This is to your benefit. This is what they don't want. I mean, it's amazing. Why are any of these attorneys that we have hired brought that to your attention? Well, they don't want you to know. They don't want you to know these little secrets. See, once you know who your enemy is, then you can address them in your complaint, in your criminal complaint.
Yeah, those are all criminal complaints, and whoever doctored up anything is going to get screwed in the end anyway. I mean, the point is it's going to come back to haunt them. Then if you start from the beginning and you let them know what's going on, you don't put yourself through all this hassle and all this stuff. They'll drop it right away, and you won't be putting through losing all this money and doing all this stuff. But if you wait to the end, then you're going to have to fight them all the way because they can't go back after a certain time.
Well, now you understand, Eugene. Now you understand why they're afraid of me. Because that's why I documented everything, and I have I have 3 folders from A to Z. I can tell. I'm not joking. I can show you who. I mean, it's so obvious. They were addressing ex partes. Honest to God, I mean, I couldn't believe it. They were addressing ex partes. I would not have known of that. If I hadn't put my documents in order by date, I would not have caught that. There's a lot of things they're going to do. You have to understand, people. They are ignorant. The reason why they're ignorant is because they know you're ignorant and you don't know the law. They are acting above the law.
Do you ever understand, Michelle, that some of these things, when you look at your trend, you say, how the hell could I say that? Well, you didn't say it. It's somebody writing from behind the scenes that wasn't even in the courtroom, changing your stuff around. Mm-hmm. They're not even there.
That is a good point. That has to do with the transcripts. Absolutely. That's a very good point with your transcripts. And by the way, Eugene is correct, because they did that with my case. They actually altered the transcripts. That's why Eugene brought up a good point when he said ask for a copy of the master recording. Very good point. Those are crucial. We're trying to help you with your case.
But there's another thing, too. When you get the copy from her, if it's changed, it's going to be screwed up, too, because they can't even get the copy that she has in the court reporter to match your transcript. Something's going to be wrong. So if you got both of them wrong, you got them ready, and then you go to the master tape, and you really got them. And the point is they can't do that. They can't. Even when they're doctoring your tape up from the woman, they're going to make mistakes. You just look for the mistakes. You got to be alert. Once you're alert, it's just...
I'm sorry, Eugene. No, go ahead. Eugene, go ahead.
Excuse me. Dave, you want to re-say that number again? Because the lady was asking for that number again.
Oh, it's 12 USC 411. And then in round brackets, 48 stat 337.
Got it. Hopefully she got it. Yeah, and it's getting... Go ahead.
You know what she could do, too, is look up the Court Reporter Act. And that tells you all the stuff in there, too, about what a court reporter can do and what can't do. So basically, if you look into that, you can type it out, too.
She can also look in the Federal Rules, Civil Rules booklet.
Right.
All those statutes and codes and the bank regulations they're all there.
Oh, another thing you might want to put in your document, I am grandfathered in on any changes in law.
Oh, thank you for saying that. Good point. That is a good point.
Anyhow, folks, we've been doing this for almost 4 hours now.
Oh, my gosh.
And so I would like to give a break to the producers, and we should wrap it up. We could get back into this further next week as we all doing our research. And this is the point. It is research, and you need to do your education and never rely on a servant. And the main point that nobody brought up, but I'm going to bring up, when the judges sit there and do these criminal acts, he is stealing public funds. His salary is a public fund. So don't forget to include that in your case, because that is fraud.
That's correct, and that falls under the trust. That's exactly right, Ed. I just want to say something, and I'm going to close. This falls under servicing of mortgage loans and administrative of escrow accounts. The statute is 12 U.S. Code Section 2605, and that's in reference to servicing of mortgage loans and administrative of escrow accounts. Again, that's 12 U.S. Code Section 2605.
Okay. I was going to ask Ed one last question before we go through the whole week. But the thing is, once that judge is not the judge anymore, he jumps on one side and breaks the law. He's not immune to it. You can get anything you want off him. He becomes dead meat, right?
Yep.
That is correct. And for our listeners, you have to understand, I know a lot of you are thinking, oh my God, there's no way I can do this. Please understand, what we were talking about tonight were many different types of cases and many different types of forms. Once you prove your evidence upon the court, it's not going to take you that long to win your case. You have to realize we're talking about cases and big cases that a lot of times you end up in court several times. Once you prove your evidence on the court, you move for a motion to dismiss. It's that simple. We probably overwhelmed you with a lot of information. It's not like you have to know all this. Well, you do have to know it as far as the law goes, where you stand. But that doesn't mean that this is what's going to happen when you take your case forward upon the court. So I don't want you to feel like, oh my God, I'm not going to be able to do this. We overwhelmed you with a lot of information.
Add one more thing to this. The case that you're seeing here in mortgage court, that could be used in any court.
That is right.
The same fraud goes into everything. So if you're out there with something else besides this, you learned a lot more today than you really know you learned, because there is no difference in the courts that teach you the same way. They can't teach you any other way.
That's why it's very important for these people to know and understand, protocol, because you are correct. That's why they need to learn the manual.
May I?
Yes, go ahead, ma'am.
Okay.
You got to know the tricks of the trade.
No, she
go
said
ahead, ma'am.
USC Section 26 of a service of mortgage, loan, and administrative something.
Administrative of escrow accounts.
Servicing of escrow account. Okay.
ESCROW, escrow? Yeah, escrow accounts. That's 12 U.S. Code, Section 26. Oh, okay. Yes, servicing of mortgage loans and administrative of escrow accounts.
Administrative or ting?
Administration.
Tion. Okay.
Yeah, correct.
Escrow account. Okay, thank you. Sometimes
You're welcome.
You talk faster than I can write.
That's okay, honey.
Go ahead.
Yeah, we can.
Oh, yeah, no, we were getting ready to wrap it up. I'm going to end up with a final thought here, and I'll let Dave do his first, and then we'll wrap it up.
Michelle, I want to thank you for a job well done tonight. And our listening audience, education is how you win in court. So you want to know your case forward and backward before you enter that court system, or they will tear you up.
Yeah, I was quite embarrassed. I have to tell you, and that is so true, because remember, to the listeners, I was just like you. I was scared as could be. I had no idea how to address the court. I was very good at addressing my documents, but I had no idea how to address the court. Remember, we're not trained in that, and we're not supposed to be doing it. That's why, remember, they violated your due process rights. So
remember too, that the court has its local rules that you must know.
That's right.
Remember to say with all due respect after everything. You know what I mean? So in other words,
yes, that's a good. Yes, that's a good point. I'm glad you said that, because remember, if you're polite in the courtroom and the judge can see that you're trying to represent yourself and you're trying to do, because the judge knows you're not a lawyer and attorney. They're not supposed to judge you the same way as a lawyer, and that's why you actually have the upper hand. You can use that to your advantage.
Michelle, we're going to wrap this up. So anyhow, anybody else has any last words to say, and then I'm going to let Dave finish his statement, and then we're going to wrap this show up.
Sounds good.
They can't treat you as a lawyer. That would be my last words. And what the judge told me on day 3, he says, I can't help you anymore because you're better than 90% of the guys that come in here. You know? But he still had to help me. See, the point is, whether you know it or you don't know the law, you're still doing it yourself. And he's got to help you. That's his job as a referee.
Mm-hmm.
That is correct. You know,
so Dave, finish up your statement so we can wrap this show up.
Okay, I'd like to say something. Thank you very much.
Go ahead, Michelle. Finish it up.
Oh, there was a lady that made a statement just then.
It's Goldie. I just want to say thank you very much.
Remember that case, Goldie?
You're welcome, Goldie. I wanted to say something that what you just said on your last statement before we close. Oh my God, I just lost my train of thought.
Yeah, Dave, would you finish your closing so we could wrap this up, because it's 4 hours.
Okay.
Go ahead, Dave.
I appreciate everyone who stayed up this late at night, because it's going on the midnight hour. Make sure you look at our new website, the new Oregon Tracker. Tell people about it. This is one way we get the word out. You have Ed's websites, Oregon Tracker, David Lee, Boost on Facebook, Tax Fraud in America on Facebook. Look at these sites. They will help you out. And above all, study, study, study. And if you find where we are wrong in something, please send us a note. You need to correct this or that. Okay?
Good point.
It's important. It is important that when we put out our educational material, it is correct. And I yield to you, Ed. Good night, everyone.
Thank you, and I'm glad for everybody who joined us. We appreciate it. We are not attorneys. We're not lawyers. We are not even judges. We sat there and read the information that we're presenting to you. Like Dave said, if you do see something that we've misunderstood, or, and I will use that word like that one, or something we've overlooked, please bring it to our attention so we can not only correct it for ourselves, but others. We do appreciate your time being with us and look forward to the future, because the main point is it's up to you and your responsibility. Make sure you are educating your children. 5-year-old children will comprehend this stuff. Trust yourself, they will. You have to have faith in your education to your children. Because if you don't educate your children, then you're the liability to your child. So may the Great Spirit walk with you, and you all have a blissful evening, and we'll get as much information out. And like I said, the new Oregon Tracker site, we do have a lot of new information up there, so please look at it. And like Dave says, pass it around, because that whole structure is what's going to get us when we're doing this, because we're putting everything as we can up on that site for your education and your children. And we'll have videos up there too, because I will be putting a couple videos on the history of this country compared to what the general public says, because they don't know all the history of this country. Anyhow, may the Great Spirit walk with you all. Travel safely, and good night.
Good night.
Good night.
Okay.
Good night.
Good night.
This is
Good night,
Toasted
everybody.
with Revolution News and Information. That was the disclaimers with Dave and Edward Johnston. It is Monday, 10/17/2016. And please join us again next Monday, same time, same place, for the disclaimers with Dave and Edward Johnston. Thank you all. Have a good night.